Happy Friday. It's time for Lawyer Reacts because it's not a coffee and cursey words kind of a day. It's a different time. We're just here together because, I talk a lot and we didn't finish our topic yesterday and there's so much more happening and we just need to get through it. And I had some plans today, so we needed to squeeze in a stream in the middle. And I was trying to let my friend Hoag's stream finish. I know he was wrapping up today on a stream regarding all the stuff going on with Microsoft. I've got water in cursey words today. We have lots and lots to cover. Go ahead and let me know where you're coming in from and what you are doing or what you are drinking this lovely morning/afternoon, depending on where you are. So, hi. We're going to jump into the topic today. No quick bits, just into it. And then because this week, I feel like we've been sprinting through our streams, even though they're 3 hours long and we have lots to cover, I'm going to try to leave lots of time for Q&A. That is the goal today. So with that, replay crew, love you. There will be timestamps down below for everything. There are Murdaugh motion hearings going on. I should have planned better because we've got all this to do. You know what? Maybe I will do a breakdown, not live, but a breakdown after those are over, or maybe we will do that on Tuesday. We'll just pop those on Tuesday and cover the Murdaugh motion hearings together. I will see if anything happens, maybe do a quick bit on it after that, because there are motion hearings going on and you guys love doing the live react stuff. I love doing the live react stuff too. And so we'll do that. I didn't even look to see. We're going to be doing a Murdaugh roundup before this goes to trial in January. So don't you worry about that. So I'll ask you guys over in our spaces what you think about doing that. But we'll have to see what happens. We'll have to see what happens at the hearings today. If it's just a quick bit, we'll do a quick bit. But yes, we've got a whole Murdaugh update. There's been a conviction in that case, well, in a tangentially related case. And there's been a lot of motions as this is leading up for trial, but we're gearing up. We're gearing up for days and days and days of Murdaugh, well, weeks and weeks of Murdaugh trial. So that's going to be happening. So yeah, I mean, you guys really like the live court coverage. Do you want to do court coverage of motion hearings? Do you want to? You let me know. Put a 1 in the chat or yes, kind of whatever. And we're going to get going. I'm going to roll the intro. I should probably go tell Twitter that we're here. I'm going to roll the intro and we're going to get going and let's do it. We're going to go through all of these things today. You guys are like, yes, you want to hear motion hearings? Okay, chat, I hear ya. I will start scheduling those, especially if it's a trial that we're going to be covering, to start looking at the motion hearings running up to it. So I will start calendaring those. And then maybe on Tuesday, I will take that stream and just go over it. So Stina G asked, could you have Mandy Batney on before the Murdaugh trial to go through a road so far? I was actually thinking about that this morning. I'm going to ask if that's something that she wants to do and have her on a podcast episode as we go through it, because we definitely need to do a road so far and catch up. So let us roll the intro and let us go into it. So it's definitely been on my mind to reach out. I really enjoy the work Mandy Batney's doing, and I want to find out how they're going to be covering it. They're going to be in court, but to see what we could coordinate with my streaming coverage and their coverage, if there's anything from court they want to share, and make sure that we have a line of communication to share the incredible work that Mandy Batney is doing over on the Murdaugh Murders podcast. So let us go. It's time for the intro. It's time. We're getting towards the end of how many times this particular intro is going to play. I have to get working on that if we're going to roll out a new one in the new year, because the new year is coming quick. Intro. Go. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts.
not fuckery.
I didn't type fast enough to get the tweet out that's what I'm talking about today. So we're gonna do that. We're gonna do that right now. So out. It's done. It's done. Let us get into these. Let's do a quick road so far. Johnny Depp, Amber Heard went to trial. Now they're both appealing. It's real interesting to watch them both appealing because when they are appealing, what we get is the the appeals on both sides. So you're getting Rottenborn making arguments that generally don't serve the other side of the appeal, like we should defer to the jury's verdict. Well, you're not saying that on the other side, because on the other side, you're like, let's overturn the jury's verdict. They're wrong. So it's real interesting to watch them argue both sides of the thing. And that's really fun when we have both appeals going on at the same time. It's a really, really rare incident that you have, or rare circumstance that you have two appeals going on at the same time in the same case, because it's very rare that you have both sides winning and both sides losing. It's a strange, strange thing. So, this is kind of an unusual situation for everyone, including the lawyers. And in that, we got amicus briefs on Amber Heard's side. I didn't see any amicus briefs on Johnny Depp's side. Why? Well, no one's really interested in whether his win or loss stands or not, but there are those that are very interested in Amber Heard's loss being overturned. And for an amicus brief, and we will get into what that is. That's going to be the second part of today's show. But for the amicus brief, which is somebody who's like, hey, we're also interested in this. This ruling impacts us. I think the best, we're going to start calling them amica. Don't worry, we're going to start calling them amica briefs, even though they're amicus briefs. We're going to start calling them amica briefs soon. Don't you worry. But we covered amicus briefs, I think, well, when we did the Onion's amicus brief in the parody case that's coming up before the Supreme Court. And you see amicus briefs in other appeals, but we cover them most often when it comes to the Supreme Court. It's someone else who is interested in the outcome. So like the Onion is really interested in the outcome of a case where a man is arrested for making a parody Facebook account to mock his local police agency for what he perceives that they're up to. And there's a really big potential that the Supreme Court could be like, no, parody is not protected speech. And so the Onion is like, parody is literally all we do. And if you find that somebody can be arrested for something they say in parody, then we have a huge speech issue. So the amicus is supposed to be someone who is going to be impacted by this ruling in one way or another, because the ruling would or could upset what they're doing. So like the Onion, with regard to whether parody has to be noted as parody, I hate the idea that you would have to say, this is parody. You want people to understand it's parody, but part of parody is a joke. Go see my video on the Onion brief. I think we broke it down well. The Onion brief, I think, is brilliant. I think they made the point so well. And they pointed out the importance of parody in that case so well. But that's generally what an amicus is for. Some organization, some company that will be or potentially be impacted, generally negatively, by a ruling, or positively by a ruling. Hey, we support this. So it is a party that's not a party that can be impacted, writing as a friend, really, of the court to support one side or the other. And those are in addition to the briefs. Like, hey, court, hear what we have to say. We are just starting to see amicus briefs in the Gonzalez versus Google case that I've touched on but haven't covered in depth yet, of those saying, hey, we need to look at Section 230 and we need to look at whether or not the algorithm needs to be protected by 230 or not. And then you get amicus briefs saying this is why we're interested in the court ruling this way on Section 230 because this is how it impacts us negatively or positively. So that's what an amicus brief is. It is someone who is not a party to the case wanting the court to hear the impact that this case could have. I'm probably not going to repeat all of that as we get into the amicus briefs here, but we will get to the amicus briefs after we get to the rest of the heard reply brief. I'm going to try better than yesterday to understand what the fuck they're arguing, because I was with it at the beginning. I was like, oh, this is clear, this is concise. And then I don't know how the wheels fell off. I don't know if my brain stopped or it was this motion, but the wheels fell off somewhere in the middle. And I'm like, what? Wait, what? Wait, what? Jessica Sunny is saying on the parody issue, so kind of like spoiler alert, joke incoming. Yeah. But if you know it's a joke, it's not nearly as fun. And that's the point of parody. It's like, wait, are they serious? Are they not serious? And then you have to look at setting. And then you have to look at at not just the setting, but you have to look at the context to kind of be like, oh, they were joking. And that's one of the things I loved about covering the Onion brief is that they pointed out the times when people thought that their parody was serious. And that's what's so great. Brittany said that chair behind you looks so comfy. It's an Amazon find. I love it. I was filming for TV and I took the blanket off. And the cats are with the blanket in the other room. So I need to bring the blanket back so the cats will come in. The cats don't love cuddling in this chair when there's no blanket there. They prefer the blanket, and the blanket's in the other room right now. So the cats have been hiding in the other room. What will happen if Amber loses her appeal? Will she be forced to pay the full amount of the lawsuit plus court fees? Joseph Via. Generally, there aren't the same types of court fees in civil cases because you pay them up front. So not the same kind of court fees like a criminal case. When you see criminal convictions, you see restitution, court fees, and all of that. So no, those would have been paid up front on the court fees issue. Pay the full amount of the lawsuit. Just sorry to be specific. Will she have to pay the judgment? There is a judgment against her for $10.3 million for Johnny Depp. That depends on whether Johnny Depp seeks to enforce the judgment. The court can help enforce it, but only if Depp asks. We've covered this a bit in the Cardi B Tasha K case, where we see we see Cardi B filing with the court to try to force Tasha K to pay, to try to attach property and homes and things like that. But once you go through the court process, it's not just that you can get your judgment. You have to go work for it. Like sometimes you have to then litigate your judgment. I don't know if Johnny Depp and his legal team are interested in litigating the judgment. I think they should be. I want them to be. You won the judgment. At least cover your attorney's fees with seeking the judgment because you won. But that becomes a whole separate court process of trying to attach property and get the judgment paid. How much of that they will choose to do, I don't know. But the court does not do that on their own. In a civil case, the civil party is responsible for it and generally for paying to go enforce the judgment. Judgment enforcement is a huge consideration in civil lawsuits. So when you sue someone civilly, you may win and you still may never see any money and have paid thousands, if not hundreds of thousands of dollars. And that sucks. It's something that when I always talked about with clients, especially when I was consulting in the civil world, it's my goal as a lawyer, and this is my philosophy as a lawyer. I want to put you in the best position to defend yourself, the best position to defend. But you also need to have a long and hard conversation about what does it look like if you have to defend. And I wanted people to understand that, like, oh, I have this contract and I have this NDA. Let's talk through so that your expectations are well set and clear. What happens if somebody breaks it? Then what does the process look like? Because I don't think a lot of people have a really realistic perception of what that looks like if you have to litigate it, what pre-litigation looks like, what litigation in trial looks like, what depositions look like, how much that all costs, that you're paying for the court reporter up front, you're paying for jury fees up front. And then if you win and the court or the jury says, you win, they suck, yay, here's money, that you then start another court process to try to get that money back. Nothing is easy. Nothing is simple. Nothing is inexpensive. And that is difficult. That's why we don't see cases like this go to trial, because most people are like, I've been defamed, I've been damaged by the defamation, and either it's going to be Streisand effect that everyone's going to pay more attention to it if I sue, or because I've been damaged with it, I don't have the money to sue and go through years of litigation to win and then have to go track down a judgment. So that's why you really don't get lawsuits like this, because most people don't have the money Johnny Depp and Amber Heard have. You know, if Amber Heard was, as she positions herself to be, truly unable to pay this litigation, she probably would have apologized and said, so sorry. You see that on YouTube all the time, where somebody will be like, I received a cease and desist. I don't know if they're right or wrong. I don't want to fuck with it. I'm done. I'm taking down videos. Apologies. We're going to back away. And then you see others that are like, sue me then. Come the fuck on and sue me then. It depends. But it is expensive. It is stressful. It is not a simple streamlined process. So we don't see people going through that. Crystal said, check your XLR wire. New mic arm might have loosened it. Uh-oh. Have we loosened a wire? Well, hopefully not. This one. Is the volume really low? Hold on. Let me check. My volume shouldn't be low. Is that any better? My volume shouldn't be low coming out at you all, but let me check my audio settings and see, because I would like y'all not to be frustrated as fuck. I would like you all not to be frustrated with volume. Audio is the most annoying thing ever. Oh, so much better. Okay, good. All right. Well, I hear a lot of you saying better, so we're going to just go with that. We're going to go with that. So if you all have to turn your headphones down, I'm sorry. Sometimes it can be picky on YouTube. There we go. But I love y'all the way I love this new mic arm. It's my new favorite thing. It's my new favorite thing. You're going to see Emily like we're going to be covering the Murdaugh case, and I'm going to be like leaned back in my chair going, what is happening? All right. We should get into stuff. I said I was going to get right into it, and we're 17 minutes in. I guess we did talk about it. Oh, it looks like Hoag's stream ended. Hello, all the Hoag friends. Hoag let me know earlier. He's like, we're going to be coming over after stream. I'm like, absolutely do. I will try not to jump on your stream. I'm always late. I had hoped to get over there, but my team meeting ran long. So with that, let us move on. Where were we? Rottenborn. Yes, you read that correctly, Mr. Rottenborn. No, I wasn't talking about injury, Mr. Rottenborn. We were talking about sex things. That text was about sex things, Mr. Rottenborn. Let us talk about this reply to Johnny Depp's appeal from Mr. Rottenborn. It is a great lawyer name, by the way. If you're going to have a lawyer villain, like Rottenborn is a real good one. All right. Emily, is your screen share ready? No. Did you know you were streaming? Yeah, like since yesterday. But is it ready? No, it's sure not. Let's go ahead and pull that up. We got to like page 40 or something yesterday. We're going to kind of look at the outline of their argument again, and then we're going to jump into where we left off. I'm going to try to make sense of it, but they were arguing both sides of a fucking thing, and I was like, damn it. What is going on? Okay. Statement of facts. They argue them. A lot of y'all are like, fuck this statement of facts. That's not what happened. That's the lawyering. Y'all are welcome to be annoyed by it. That's the lawyering. They're going to pose the statement of facts in a way that is most favorable to them. That is what you do. Rottenborn is a zealous advocate for Amber Heard. That is his job. So unless things are really bad, I try not to hold it against the attorney, because it's like, you're doing the lawyer things. So, light most favorable. Even when we pointed out, well, that kind of makes it seem like this, we're just pointing it out. They're doing their thing. The other attorneys are going to point it out too. So, light most favorable to Amber Heard. When we were going through it, it was like, why are you making some of those arguments? They're really trying to say that Depp intended to retaliate against Miss Heard and hired Waldman for that purpose, so that Waldman's statements about Miss Heard are in the context of him being an agent of Johnny Depp. meaning Johnny Depp is responsible for what the agent says. Why do I think they're doing it that way? Well, because what you're not going to be is responsible necessarily for an independent contractor. You're going to be responsible more for an agent or an employee. When they're an employee, that agency relationship is so much easier to set up. They are trying to argue it doesn't matter. It doesn't matter if Depp and Waldman are not in an employee-employer relationship. The agency is established either way. And that's what Depp's intention and their relationship is for, to show agency. Waldman is doing, they are arguing what Depp hired him to do. And what Depp hired him to do was retaliate against Amber Heard. Because fuck her, that's why. That's their argument. They're saying the motion for summary judgment, motion to strike is kind of irrelevant to this whole thing. That ship has sailed. You're too late. Refused jury instruction. They're saying that that was proper. And then argument. So we got through like the statement of facts that went to each thing. And then we start over with the argument. This is answering directly what Depp is arguing. I think these are interesting arguments. I like seeing how Depp's arguing this. I want to see the court take it up. I think we're going to end up seeing more and more cases where people are arguing, well, the lawyer said this and the lawyer said that in the course of the relationship, but outside the course of litigation. Because when lawyers speak within the context of litigation, it's generally covered by litigation privilege and you cannot sue over it. Or you can, like, hey, this shit's defamatory. And then somebody would be like, great, you think that's defamatory, but it's covered by litigation privilege. Because remember, defamation is a non-privileged statement. So when you have these carve-outs for you can talk shit on someone that may or may not be true in certain contexts, because how can you as a lawyer be a zealous advocate for someone if you can't put forth theories and argument that they may otherwise find unflattering? And it's not defamatory given the context, because lawyers are held again to other standards. So it's like there's already a control for this, and the control is the duty of candor. The control is that the court can sanction you if you get all buck wild. I mean, should sanction you if you get all buck wild. And there is a control within the confines of litigation, but the control doesn't need to be sue for defamation. Sue for defamation is a control on the First Amendment, right? It's like, sure, you can say what you want. Sure, most speech is protected from the government saying you can't fucking say that. But the control on that is if you lie on someone's name, they can sue the fuck out of you. The way that our system works, though, with how expensive it is, that control doesn't always work, and people run rampant on the internet just spewing things. It's the internet. It can be very mean. Like, buyer beware, it's the internet. Caveat emptor. It's the internet. So generally the litigation privilege applies. So there we go. Litigation privilege applies. That's normally the control on lawyers saying wild shit. And in this case, they're saying, no, this is outside of litigation. Litigation privilege doesn't apply here. This is an interview. Litigation's not ongoing. This is not like a press release saying we think this or that. It's different. And he's also an agent. Normally, you would just sue Waldman for the shit that Waldman says. In this case, they didn't sue Waldman. They sued Johnny Depp for what Waldman said and say that he's an agent of Johnny Depp. And Johnny Depp's like, he's not an agent. So that's really what the argument is here. I'm very interested to see the court take it up. And we're going to see this play out in the Gabby Petito, Brian Laundrie family lawsuits where the parents are suing because the parents are also trying to sue the attorney. This came up in the very first hearing. And I will, if those hearings are streamed, I will try to stream those in the future as well. It's going to be an interesting legal argument where they are trying to sue the lawyer over the things the lawyer said when he was representing the Laundries. I don't know how that's going to fly. And that's going to be a difficult case because a lot of people are like, yeah, but fuck them. I want it to fly. It doesn't mean it legally will. And that makes it a very difficult case to cover. So we will break that down because we're law nerds and that's what we can do. We can put aside the legality and the morality of the thing, and we can put aside the feelings and the law and have a conversation about it. And We've already seen the judge reference this case. We've already seen the judge reference that Johnny Depp was held liable for what his lawyer said. It's already come up and it is going to continue to come up. I'd really like to see the appellate court say something one way or the other. Standard of review, great. That's where they get into the case law. Case law. Waldman can be both an independent contractor and an agent. So they're saying employment is not the only way to have an agency relationship. And they are trying to argue that employment's not the only way to have an agency relationship. Heard presented sufficient evidence of actual malice. I missed where they put that evidence into this motion. So, and then they argued on that same page, Depp waived any argument that summary judgment should have been granted. Fine. Ms. Heard can prove defamation by showing either Depp or Waldman had actual malice. Fine. And then they only argued that Depp had actual malice. And then they tried to say, but Waldman should have known that what the police officers said was this or that. It was a rough one. It was a rough one. The statement is actionable because it contains provably false factual connotations. This is talking about, you can't just yeet the entire statement. It's not opinion. And then we're here with regard to the jury instructions. So that's where we're going to jump into today. The rest of it I covered yesterday. So let me zoom to page 40-ish. Like we're going to just start at that section because it'll just be a clean place to start with the jury instructions, even though it might overlap a little bit. No, I'm reversing myself. We're going to look at a little bit about what they said about actual malice. Because yesterday at the end of stream, I'm like, what are they even saying? What are they even saying? Let's see. That's about as big as it's going to get. All right. Waldman had actual malice. Waldman testified he had no firsthand knowledge of whether Mr. Depp abused Miss Heard. It's an interesting opening statement because he says, I wasn't there. Like, I don't know. I wasn't there. I don't know. I wasn't there. Waldman testified he had no firsthand knowledge of whether Mr. Depp abused Miss Heard, but claimed he saw, quote, some things that shows her statements to be false. I guess that's the evidence that he should have known. I guess. When describing those things or these things with respect to May 21st, 2016, Waldman testified. So there are two police officers, one domestic violence trained female police officer who testified over and over and over that there was no damage to the penthouse, which Miss Heard claimed was destroyed. That's a direct quote, destroyed. So it seemed to me that Rottenborn is trying to argue that because Waldman said the officer said there was no damage, that when he made the statement they roughed up the penthouse, he knew he was lying. I think that's where they're going with this. But he's saying the officers saw no damage, which is also in his statement. The officers saw no damage, so then they went back and roughed it up. I think Waldman is thinking these are the first group of officers that saw no damage. So this is why law school takes so long. So Rottenborn is trying to say, look, he knew it was a lie because he testified that the officers saw no damage. Therefore, he knew it was a lie. And the way I saw this go down in the trial is that, or the way I think this went down, if memory serves, is that Waldman thought this was the first set of officers. And so then he says the officers came out and saw no damage. This is consistent with that statement. So it's parsing the timing of it in a very narrow way. But if we've learned anything, lawyers split hairs. That's what they do. These judges are going to read the entirety of this testimony, I'm sure, and take a look for themselves. Based on this testimony, a fact finder could have concluded that Waldman believed there was no damage to the penthouses. He's like, full stop, no damage. Not no damage at this point and more damage at this point, but full stop, no damage. Here's why this argument's confusing to me, because either before or after this, somewhere in this motion, he argues that they admitted pictures into evidence showing that there was damage to the penthouse. So he's saying a reasonable fact finder could have concluded that Waldman believed there was no damage to the penthouse, but we also put in pictures showing there was damage. So a fact finder could have said, well, Waldman believed there was no damage until they damaged it. But they didn't. Obviously, they didn't believe that because they found this statement defamatory. It goes on to say this conclusion would have been supported by the testimony of 3 law enforcement officers who responded to calls to investigate domestic violence at the penthouse. So are you saying that Amber Heard damaged the penthouse? Wait. This is why we needed to look at this fresh. This conclusion would have been supported. So they're saying Waldman believed there was no damage to the penthouse. And the conclusion that there's no damage to the penthouse is supported by 3 law enforcement officers. But they talked about the fact that they put in photos to show damage. So where did the damage come from? The conclusion that there was no damage to the penthouse is supported by 3 law enforcement officers who responded to calls to investigate domestic violence at the penthouses. All 3 officers saw no damage. The jury could have inferred that Waldman spoke to these officers or reviewed their testimony when reaching his conclusion that there was no damage to the penthouse at any point in the evening. But then why'd you put in pictures showing there was damage? Yet, Mr. Waldman told the Daily Mail that there was damage to the penthouses. Amber and her friends spilled a little wine and roughed the place up. I mean, there was mess. There were pictures. You put pictures into evidence. Wait, we got to go back. Okay, I'm on page 35. Hold on. I'm making a note. We got to go back and look at what he said in his brief. Because they admit that there was damage. They admit pictures showing there was damage. And so Waldman, I think, got the timing wrong because he said the damage was in between the 2 officers coming out, wherein it could have been that the damage was after all the officers left. So they're arguing against their own facts, which is odd. They're saying Waldman could not logically believe both that there was no damages to the penthouses and that Miss Heard damaged the property to fabricate evidence. I think he believed both. That there was no damage to the penthouses when the officers were there and that they then damaged the penthouse later. Because damage to the penthouses, you tried to prove. We got to zoom. We got to zoom to the fact statement. I'm going to try not to zoom at you. We're going back to the statement of facts because in the statement of facts, they said there was damage. It's just very odd that they're arguing literally against their own evidence. Because they're arguing that Depp damaged the penthouse. All right, let's go back to the statement of facts. This is from May 21st. When Mr. Depp arrived in the early evening, he was inebriated. He was peaceful at first. Then he got pissed about the grumpy. Then he was yelling at Io. Then he became angry, grabbed the phone, screamed at Io, yelled expletive insults, told Io he could have Heard, tossed the phone on the couch and proceeded upstairs. Heard retrieved the phone, began apologizing to Io. Io was still on the phone, told Amber to get out of the house. Depp came back down. This is their statement of facts. Depp yelled at Io. Depp threw the phone at Heard, sitting on the couch. Heard said she was hit with the phone. They allege he grabbed her by the hair. Where is Io called 911. The physical altercation subsided when Rocky came in. At this point, 2 of Depp's security guards entered the apartment and persuaded Depp to leave. Okay, so no damage at this point. As he was leaving, Depp picked up a Magnum wine bottle and smashed various items of personal property. The damage to the property included framed photos, displays of bead necklaces, etc. Depp also spilled wine in the hallway outside their home. This timing doesn't work because the first officers that show up didn't smell any wine, didn't see any wine, and didn't see anything smashed. This is part of the problem. This timing doesn't work because the officers say they saw no damage. And now they're arguing later in this brief, that there's no damage. And no wine. So I think their argument, look, Waldman would have known, or a jury could conclude that Waldman knew there was no damage because there was no damage, argues against them saying Depp damaged it. It argues against their own statement of facts. I saw a question from the chat I want to grab because it was great. This is a great question, Speckle. Are appeals done entirely in paper or also in person? It depends. If the appellate court wants oral argument, they will ask the parties to come in, and then those are audio. So if there is oral argument, in theory, we should be able to hear the oral argument, but they can be done entirely on paper, which is why I don't cover appeals a lot. Why? They're not as fun. Appeals are not as fact-based. I'm very interested in, I'm interested in the game, not the calls on the replay. These are all the calls on the replay. I'm very, very much more interested in the lawyers lawyering pre-litigation and during litigation. Sometimes we have to cover the replay, and we're doing that now, but I'm way more interested in the craft of the lawyering on the field, in the game itself, not in how the referees are deciding the calls, if that makes sense. This is the referees, Monday morning quarterbacking, going, should the court have decided that? I don't know, maybe. Do we need to change that? Like the appeals court will look at, the rule is this fact pattern happened. That rule didn't get applied the way we thought. Maybe we should change the way we interpret this law. Maybe this law isn't a good law. Maybe this law isn't a lawful law. Maybe we need to change it. It's like running tests on software. When you get a wonky result, you're like, oh, that's not the result we thought would happen. Maybe we need to change some things. That's what the appellate court's doing. So mostly on paper. So it's interesting that they're arguing against their own fact scenarios, saying, look, the jury can believe that Waldman knew that there was no damage. So the jury could find that Waldman was lying when he said there was damage to the apartment, because we are arguing that a finder of fact could find there was no damage. But that means that the jury can find that your client was lying too, which they did. So maybe that's the best argument. Hey, our client's lying about this damage that we just put in this fact scenario. And because Waldman says there was damage, Waldman knew there was no damage and said that there was damage. So Waldman is guilty of defamation for lying about there being damage. Okay. Is that the argument that's happening here? They say Depp left with security guards, heard learned right, called 911, and then panicked because she did not know what law enforcement was going to do. And when it saw the property damage to her home. Well, the police didn't see any damage. You're saying there was no damage, or a jury could conclude that there was no damage. But if a jury concludes there was no damage to the home, then they're concluding that Amber Heard lied about all of this. Right? Meekin said, so are they trying to infer that Amber Heard committed perjury? I think they're trying to infer that they're saying the jury didn't believe her, and therefore it's also defamatory when Waldman said this. Or maybe that's not their intent at all, and we're just reading into it. But they're arguing that the jury could, I'm zooming back to where we were. They're arguing that the jury could easily find that Waldman lied because he knew there was no damage, because there's so much evidence that there was no damage. But it's in the same brief where they say, we submitted all this evidence about damage. The conclusion would have been supported by the testimony of 3 law enforcement officers, the conclusion that there was no damages to the penthouse. Based on the testimony, a fact finder could have concluded that Waldman believed there was no damage to the penthouses on May 21st, 2016. So based on the evidence, a jury could conclude that Amber Heard was lying. That is what this appellate brief says. Am I wrong? Chat, if I'm wrong, tell me I'm wrong, because I don't know how else to read this. Other than, based on the evidence, a jury can find that Heard was lying about damage to the penthouses on May 21st, 2016. Am I missing something? That's what they said. This conclusion was supported by the testimony of 3 law enforcement officers who responded to calls to investigate domestic violence at the penthouses. All 3 officers saw no damages. And the jury could have inferred that Waldman spoke to these officers, reviewed their testimony when reaching his conclusion that there was no damage. So they're saying the jury can find that Waldman knew there was no damage. Therefore, when Waldman says that Amber and her friends spilled wine and roughed the place up, he was lying. So a jury could also conclude that when Amber came in and testified that the place was damaged, that she was also lying. Waldman could not logically believe both that there was no damage to the penthouse and that Miss Heard damaged the property to fabricate evidence. Disagree. He could absolutely believe that there was no damage to the penthouse when the officer saw it and that at some point she damaged it, but the timing in his statement is wrong because the timing in Waldman's statement puts the damage done by Amber and her friend in between the 2 officers coming. And I think the jury went, well, the evidence shows there was no damage. We think Amber Heard's lying, but you also said that she damaged it and that wasn't done, if it was done, till after the officers left. So I think Waldman could logically believe both. I think he got the timing wrong, but all right. The jury could not have found Waldman's testimony contradicted his belief in the truth of the statement, thereby demonstrating that he knew it was false or was reckless with respect to its falsity. He knew it was false. She didn't. Your Honors, esteemed members of the appellate court, Waldman, there's evidence of malice because Waldman could not have believed that there was damage. Nay, don't look at my client putting in all of this evidence of damage to the penthouse. Don't look at the statement of facts that is 20 pages up. Don't look at that. He knew that the officers said there was no damage. And he said that she did the damage before the second officers came. And the second officers didn't see any damage. Because, Your Honor, she did the damage after the second officers left. But we're not going to say that because that's not what Waldman said. I don't know if this is the serve you think it is. The jury could have found that Waldman's testimony contradicted his belief in the truth of the statement. Well, that's what they found as to Heard, isn't it? Rochelle said, didn't they submit photos of the damage? Yes. Yes, they did. Copious cookies, we are talking about 2 sets of officers. There were 4 officers, but only 3 testified to my memory. They're arguing that this is why my head hurt yesterday. They're arguing that a reasonable jury could find that Amber Heard lied. But Rottenborn is saying that. And that's, I think, where my brain broke at the end of the stream yesterday. Rottenborn is arguing that a reasonable jury could look at all this evidence and find that Amber Heard lied. Ergo, and then find that Waldman lied because he said the damage was done in between the 2. Well, that goes directly against their appeal on the other side. That there wasn't enough evidence for the jury to find that Amber Heard lied, because they're arguing here that there is. Oh boy, I'm going to be referencing this brief a lot going forward as we're looking at the Amber Heard briefs again. Because he just made the argument that a jury can believe she lied. So, because three officers contradicted her testimony. And if they find she lied about the 21st, they can find she lied about everything else. Charlie asking the real questions, does Depp get to respond to this brief? Yes, and I hope what they say is, so we all agree that Amber Heard lied. And they start there. We all agree that Amber Heard lied. But that's not the issue here. The issue in this brief is, was Waldman an agent? Not whether Waldman, well, I also don't think Waldman had actual malice, but was Waldman an agent? Am I wrong? Am I reading this wrong? Y'all? Tell me. So the argument here is a fact finder could conclude that Waldman believed there was no damage. That belief is supported by the testimony of 3 officers, yet Waldman told the Daily Mail there was damage. Waldman could not logically believe both there was no damage and damage. I think he believed that there was no damage until she did the damage. The jury could have found that Waldman's testimony contradicted his belief in the truth, thereby malice. Like, this is the Matrix. Yes. Chat is bae. This is the best comment ever. Hold on.
You continue to read that right. Thank you.
We continue to read that right. I'm just. And he bets Ben Chu is doing the same thing as Emily, probably with more cursey words. I haven't cursed nearly enough for this. Also, I imagine that at their firm, they had multiple attorneys read this and be like, can you parse this argument? Because I want to make sure I'm not missing something. Because am I missing something? I'm going to get in my group chat after this with everybody who's read this and be like, did I read that right? In addition, it says, when making the statement and others as Mr. Depp's attack dog, ruff ruff, and when he filed a police report for perjury simply so he could tell the press falsely that Miss Heard was being investigated for perjury, I feel like you might have just argued that she committed perjury during the trial, but that is after the fact. Waldman I'm being facetious in that. He's not arguing she committed perjury. He's arguing that a reasonable jury could find that Amber Heard lied. That's what he's arguing. Ergo, find Mr. Waldman also lied. Mr. Waldman selectively credited only the evidence he believed was favorable to Mr. Depp, like a lawyer would do. Like a lawyer would do. They would credit the side most favorable to their client. They're not obligated to present both sides. In fact, asterisk, there are limited circumstances wherein a lawyer is required to present both sides, but in most of the time, especially in civil law, you get to be a zealous advocate for your client and you are not required to present the other side's argument as well. Waldman selectively credited only the evidence he believed favorable to Depp. He's not talking to a court of law. He's talking to the Daily fucking Mail, and ignored the abundant evidence of Mr. Depp's abuse of Miss Heard, including the evidence regarding the night of May 21st, 2016. The evidence that you just said a reasonable jury could find didn't exist. That evidence, the evidence of nothing, the absence of evidence. Wait. We're like a paragraph. We're never getting through this today. We're going to be here all day. They just argued that a jury could find that Waldman knew there was no damage. And now they're saying, but there was evidence of what happened the night of May 21st, after arguing that a jury could believe that nothing happened the night of May 21st. Or maybe they're only arguing about the damage of the property and saying, well, everything happened but the damage of the property. Therefore, a jury could reasonably have concluded that he either knew his statement was false. What? The perjury has nothing to do with the Waldman statement, though. Like, this whole paragraph needs to be yeeted. Yeet this entire paragraph. This is not helpful. Yeet. This perjury has nothing to do with spill a little wine and roughed up the place. Literally nothing. Shush. The statement is actionable because it contains a provably false factual connotation. And this is the standard of review. The statement's not protected. It's not a statement of opinion. We covered that yesterday. I don't think it's a statement of opinion, truly. I think he's not saying in my opinion. He's saying this is how it went down. I can agree with that. We covered that yesterday. No, we're going to do it again. Sorry, because now that I'm like, wait, we're arguing out of both sides of our mouth, I'm confused. While pure expressions of opinion are constitutionally protected and cannot form the basis of a defamation action, there is no wholesale defamation exemption for anything that might be labeled opinion. The test for distinguishing pure expression of opinion from actionable factual assertions, actual factual. It says actionable. I'm saying actual. I'm saying actual factual because it's funnier. Actual factual assertions is whether the statement contains a provably false factual connotation capable of being proved true or false. Is it true or false that they roughed up the place in between the two officers coming? And the jury said, no. The second set of officers also didn't see anything. The statement, which clearly contains provably false connotation, reads, quite simply, this was an ambush, a hoax. I think the jury believed that. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, left after seeing no damage. So Amber and her friends spilled a little wine and roughed the place up, got their stories straight, and placed a second call. I think this sentence is where the jury's like, that's not how the evidence came out. Because that's not how the evidence came out in trial. That's not how the evidence came out at trial. So I think if this statement had been, so Amber Heard and her friends roughed the place up, took a bunch of pictures, and said that something happened, you might have been in a better position. But you get the second set of cops, and there's no evidence of a second call that was presented at trial. I know the internet differs, but at trial, we didn't see any evidence of a second call. The evidence we saw at trial was that there had likely not, the call had not been cleared. Even though in the internet world, there is a second call, that was not presented at trial. What came out at trial from the officers is this call was still pending, so the second set responded. Not that there was a second call. So, Carol, captions go on after the stream. I cannot live caption the stream well because it requires a substantial delay, which makes it very, very, very hard to interact with the chat. So captions will be on in the replay. The assertions in the statement are capable of being proven false with evidence that Miss Heard and her friends did not call law enforcement on May 22nd. Well, they did. There was just no evidence at trial that they called a second time. Spill wine or rough up the couple's home. That could have happened after all the officers left. There was no evidence of a second call presented at trial, and that, I think, is the problem. Fabricate evidence of domestic violence or contact a lawyer or publicist. Evidence could also be presented to demonstrate the officers who responded saw Miss Heard's injuries and property damage, but did not conduct a thorough search. What? What? Evidence could also be presented to demonstrate the officers who responded saw Miss Heard's injury and property damage, but did not conduct a thorough search. This is the literal stretch of a lifetime. I'm glad we decided to go back through this part. The stretching here. Oh, Your Honors, no. I literally need hand lotion. Your Honors, no. The officers came, they saw the injuries to Amber Heard, but they didn't search. So we find that this statement is defamatory because it said the officers thoroughly searched, and that didn't happen. What? The jury took issue with the words of the thorough search. No, the jury saw body cam footage and heard from 3 officers. The thorough search is not the problem. The thorough search is not why the jury found this defamatory. I think the jury saw no evidence of a second 911 call. I think the jury could reasonably have believed that Amber and her friends did this after both sets of officers left. Evidence could also be presented to demonstrate the officers who responded saw Heard's injuries. What evidence could be presented when? What, the trial happened. Be presented when? Be presented when? The contention that Miss Heard carried out an ambush or hoax is falsifiable because Miss Heard can and did prove Mr. Depp abused her on May 21st, 2016. to be completely fair to Rottenborn, we're not talking about truly, I don't think on the 21st, the jury's focused on abuse. I think the jury's focused on what happened at the place and whether there was wine or the place was roughed up. And the officer said there wasn't. So they didn't say anything really about abuse here. They say it was a hoax and an ambush, and that, oh, well, no, I guess damage to face is part of it, but the officers didn't see that. And they testified that they didn't see that. So I think he's trying to walk it back a little bit, but I don't think it's persuasive. It's not a persuasive walk back. The contention that Miss Heard carried out an ambush or a hoax is falsifiable because Miss Heard can and did prove that Depp abused her on May 21st, 2016. I don't think that's true, because the jury did not find the straight up hoax statements to be defamatory. The jury found, I think, the second call information being the problem based on what came out at trial. But I think he's trying to walk it back to say, no, Amber Heard did prove that Depp abused her on May 21st. Those are the photos that were so at issue. To the extent these phrases are opinions, they are nevertheless actionable because the remainder of the statement sets forth a factual basis that supports these assertions. If the jury had found that Depp abused her on May 21st, 2016, if Heard did prove that, then it's really hard to reconcile the jury finding that her statements in the Washington Post were defamatory. If the jury believes that Amber Heard was abused by Johnny Depp on May 21st, then you cannot reconcile these. You cannot reconcile these two verdicts. If you believe that the jury was parsing facts and didn't believe a second call was placed and didn't believe that she spilled the wine and then showed it to the police, that's the only way these two verdicts are reconcilable in my mind. Depp does not challenge that the statement contains a provably false factual connotation. Instead, he maintains that the context of the statement transforms it into opinion. When determining whether a statement is actionable, courts examine the statement in context by applying the general rule, words are to be taken in their natural plain meaning. The problem is they're arguing that there wasn't enough context for the article. And you guys are Tracy and Judy over on Facebook are saying, agreed, she would have won. Right. If they found that Depp abused her on May 21st, she would have won. I think so too. And they're arguing that the statement needs to be taken in context. Depp's team is arguing, right, but we didn't have the context of the whole article. Here, the statement makes objective assertions about the events of May 21st, 2021. The only plain and natural meaning a person would draw from the statement is that these events, in fact, occurred. And I think, again, that's where the timing becomes an issue based on the way the evidence came out at trial. So. Let's keep going. Relying on Riley versus Haar, Mr. Depp contends that a reader would understand the statement as Mr. Waldman speaking as a legal advocate and offering his own interpretation of disputed evidence. I think that's a reasonable argument. The problem is the jury didn't have that because you didn't have the full context of the articles, which is something they're arguing about on appeal too. I don't think they're going to win on that. So, in Riley, the First Circuit observed, quote, even a provably false statement is not actionable if it is plain that the speaker is expressing a subjective view, an interpretation, a theory, conjecture, or surmise, rather than claiming to be in possession of objectively verifiable facts. And I think that's why Depp's team used this case. But to argue, look, you have to give us the rest of the article to show that this is a response to the other side. While no Virginia court has adopted this principle, it applies only where an author outlines the facts available to him, thus making it clear that the challenge statement represents his own interpretation of those facts and leaving the reader free to draw their own conclusion. I mean, I think that's why they're arguing that they need the context of the whole argument to show that the facts are in dispute, because the other part of that article in the Daily Mail is somebody advocating really for Heard, saying, no, this is Heard's side of the story. And this is, no, this is Waldman's side of the story, Depp's side of the story. Waldman did not outline the facts available to him in the statement, although the article notes that Mr. Depp's legal team pointed out that the 911 caller on May 21st, 2016 had a female voice, and the LAPD registered IO's call at 10:09 p.m. This explains at most why Waldman asserted that 2 calls were made. Well, 2 calls were made, but this didn't come out clearly at trial. The Rocky Pennington call didn't come out well. It did not come out well at trial. The reason I know enough about the Rocky Pennington call is because of other content creators, like The Real Laura B., Tug, and others, not from the trial. This evidence did not come out well at trial. It did not. And that's where there's confusion. Because there were 2 calls. The jury doesn't know that well. We know that well, but the jury doesn't know that well. This is why when I covered the trial, I'm going to sidebar for a second. We're going to be here forever today. Happy Friday. This did not come out well for the jury. And this is why I tried to watch this trial without a ton of knowledge from what had been available outside of court, available to the public, available from the UK case. I really wanted to be able to parse in my brain what we know in the internet world and what is known to the jury. I wanted to be able to keep those 2 things separate. And the 2 call back and forth did not come out clearly to this jury. It did not. But it is known that there were 2 calls. It is known. Rocky made a call. Io made a call. Io made a call from New York. That call is going to have to get registered through and parsed through to LAPD, because that call, a 911 call in New York, is going to go to local. So it's going to take time. So the jury doesn't know. The jury heard that Io made a call and then police arrived, and that the second group of police didn't quite know why they were being set out. They weren't clear on the dispatching. Like, it wasn't clear from their MDT notes. There is no explanation of facts that could be interpreted as supporting the defamatory assertion that Ms. Heard set up Mr. Depp by fabricating evidence of domestic violence. I just simply disagree. Mr. Depp also asserts that courts consider factors such as whether the form in which the statement is made would cause a reader to understand it's the author's opinion. Again, an argument towards why the whole article needed to come in. Chat, I would love your thoughts on this. I don't know. Love Dreaming Peach asked, why wasn't this clarified during the trial about the 2 911 calls? I don't know. I would love to know. I don't know. It was not made very clear. I don't know. I don't know. It didn't come up. I would need to go back and watch Rocky Pennington's deposition that was showed. I don't think it ever came up that Rocky called the police that night in her depo. I think it would have been helpful. So chat, you are welcome to input on that. I truly don't know. The degree to which the audience is familiar with the underlying facts and the identity of speaker. This is Depp arguing you need the whole article to make it make sense. Each of these factors suggests the statement is not an opinion. The form is the Daily Mail. I mean, a widely circulated tabloid. That would be the context as to why it might be opinion and not fact. The form is the Daily Mail, a tabloid. Maybe that. Maybe that. Maybe that's the context clues you need. That publishes newsworthy accounts of factual events, not opinion pieces. The overwhelming majority of the Daily Mail's numerous readers are not familiar with the underlying facts of Amber Heard's abuse. And the identity of the speaker as Mr. Depp's attorney suggests he has insider knowledge or access to evidence that establishes Ms. Heard's allegations are false. Again, this, to me, all leans towards why you need the whole article, even though the article is hearsay. While the reader might consider statements an attorney makes in court as mere advocacy, the press is not a traditional form in which attorneys advocate for their clients. Lies. What? Um,
I think that the press is a very traditional form where attorneys advocate for their clients, at least post, like, I don't know, 2000. This is the way. This is just what happens. Attorneys that talk to the press are doing so to advocate for their client. I mean, what?
in sum, the context of statement does not transform its factual assertions into opinions. For this reason, the circuit court correctly denied the motion for summary judgment and motions to strike the evidence. Okay. All right, the jury instructions. I'm actually very excited about this part. So what did Elaine do on TV? Exactly. Elaine. Oh, hey, real Laura B. Io Tillett claimed it was a friend, not Rocky, who was at Hollywood Cemetery watching Silence of the Lambs. Interesting. There's a lot of contention over this. To what extent is zealous advocacy allowed within the ethical confines, which gives you a lot of leeway within the ethical confines of being an attorney, but zealous advocacy has a lot of grounds. The circuit court correctly rejected the proposed jury instructions on independent contractors. These jury instructions are confusing. Laced in Chains said they use tabloid and factual synonymously. The decision to deny jury instructions rests with the discretion of the trial court and will not be reversed absent an abuse of discretion. This is the highest standard. This is a very hard standard to meet, which is why Depp structured their brief with the most easy to the most difficult arguments. This is the most difficult argument. The sole purpose of appellate review of jury instructions is to see that the law has been clearly stated and that the instruction cover all issues which the evidence fairly raises. And Depp is arguing, but the evidence raises the independent contractor question, and the jury instruction doesn't adequately cover that. They say it fully and fairly covered the principles of agency. As previously explained, the concept of an independent contractor does not apply to this case. I disagree. Because Mr. Depp's liability stems from Waldman's role as his agent when speaking to the press. And even if Waldman is an independent contractor, it does not preclude Depp's liability for his conduct. Therefore, proposed jury instructions 22, 23, and 24, which concern independent contractors, are not accurate statements of the relevant legal principles. I mean, at least it's a linear argument. Additionally, they refuse jury instructions on independent contractor overlap, or the refused jury instructions overlap with the current instructions on agency. It's fair. It's fair to say, look, the court said no, and it's a no. It's a no for me, dog. A principal is a person or legal entity with power or right to control the means and methods of performance by which another person performs the principal's work. An agent is the person who is subject to the power or right of a principal to control the means and methods of performing the work. And this is where a lot of the legal argument comes in. A client is not a ton in control of the means and methods of a lawyer performing the work. They're not. They're just not. Pam J, make me want to go to my kitchen. Just try the Screwball peanut butter whiskey. It's delicious. It is. It is. It is. And maybe I should go to my kitchen. my kids are being brought home from school today by not me. I don't have to go anywhere the rest of the day. Maybe I should have just, but I didn't. I wanted to get through this without my head popping off. Clients have input, but lawyers have ethical duties that even if the client says, do this, the lawyer is like, no, I cannot do that. I am bound ethically by my duties as to the bar that I cannot do that. So this gets into independent contractor stuff too, but a lawyer the client can say, I want to do this, but they can't control the means and methods of the lawyer doing it. So, proposed jury instruction 22 effectively defined an independent contractor as the opposite of agent because the things are not analogous. An independent contractor is not in the control of a person, and that's this entire argument. An independent contractor is a person who is engaged to produce a specific result. But who is not subject to the control of the employer as to the way he brings about that result. Hey, I need you to protect my rights. And the lawyer's like, okay, what we're going to do is this. Catherine Frazier, with a little love for the mods at 12K and no porn bots. Yep. YouTube has also rolled out some stricter controls to kind of cut down on those kind of things, and it's been really great. The YouTube creator liaison, Renee Ritchie, has been heavily working behind the scenes to cut down on those types of spam bots and to cut down on impersonation accounts, and it has made a noticeable difference. It makes me never want to stream anywhere else. Unless Twitch wants to give me an exclusive deal. I'm teasing. I love YouTube. It makes it very easy to moderate and to keep our community. If you find that Mr. Waldman was acting on Depp's behalf but was not subject to Depp's control as to the matter, method, or means, you must find that Waldman was an independent contractor. I can see why they wanted the instruction. Both instruction TT and proposed instruction 22 explain that liability depends on whether Waldman was subject to Depp's control. They're saying that those two instructions are kind of mutually exclusive. In light of this redundancy, the circuit court did not abuse its discretion by refusing proposed jury instruction 22. Moreover, Mr. Depp suffered no prejudice due to the refusal of the jury instruction. I think if the jury had that instruction, they wouldn't have found that Waldman was subject to Depp's control. Whether that's prejudice or not, we'll see. I mean, I don't know if they will find it prejudice or not. This is a high standard to meet. Proposed jury instruction 24 is duplicative with the given instructions and the burden of proof. Instruction 20, provided misheard, has the burden of proving the greater weight of the evidence that Mr. Waldman was an agent of Mr. Depp and that Mr. Waldman was acting within the scope of his agency when he made the statements. The proposed instruction says a person who hires an independent contractor is not liable for the independent contractor's actions. If you find that Mr. Waldman was an independent contractor of Mr. Depp instead of an employee, you may not find Depp liable for Waldman's conduct. That's my understanding of the law. Truly. But you can't have that instruction on its own. You also have to have the other instruction saying this is what an independent contractor is. The jury instructions on the burden of proof adequately explain Depp's liability turned on proof of agency. So they're again arguing that, look, we're on an agency theory, independent contractor, employer is irrelevant. It's tough. Proposed instruction 24 expresses the same false dichotomy made above. I'm really interested to see what the court does with that, because I don't think it's a false dichotomy. I think it is you're an independent contractor or you're an employee agent. That's my understanding. I'm interested to see what the court says. Because if my understanding is wrong, I'd sure like to know. Proposed instruction 24 also expresses the same false dichotomy discussed above per, Wikipedia. The jury may find Waldman was an independent contractor instead of an employee. This assertion would have confused the jury by indicating Heard was required to show Waldman was an employee. And therefore, there was agency. Finally, the circuit court did not abuse its discretion by refusing the proposed jury instructions because giving it would have invaded the provenance of the jury. It is fundamental that the court must respond to questions of law and that the jury to questions of fact. I mean, Depp should have argued more that as a matter, he did argue it and the court was like, no, that as a matter of law, that there's no agency. But that's not what happened here. That's not what the court decided. So, proposed jury instruction 23 stated an outside lawyer retained by a client in connection with litigation is an independent contractor. And they're arguing this, Heard's arguing, which is, look, on a legal argument, this is good lawyering on Team Heard. Team Heard had a lot of fails. This is good lawyering on Team Heard, and this gave them a win. Because this is good lawyering on Team Heard. This is, hey, Waldman wasn't just in connection with litigation. He was making statements to the press. He was showing up at interviews. He went beyond the scope of litigation, and therefore this applies. And this was a win for them. This is why they won on this count, because they won these arguments early on in the trial. They lost some of the arguments they really wanted, like this shouldn't be in Virginia anyway. But they won on this because they were able to convince the judge of this distinction. Look, he is not just retained in connection with litigation. I think that's their strongest argument here. The circuit court did not abuse its discretion by requiring redaction of irrelevant and inadmissible portions of the article. I like Depp's argument on this. Hey, you need context. And they're going, hey, the context is hearsay. This cuts both ways, though. You know why? Because her notes to a therapist are not context. They're also hearsay. If this is not context and hearsay, that is not context and hearsay. The court was very consistent. Standard of review decisions regarding the admissibility of evidence lie within the trial court's sound discretion. This is abuse of discretion standard. This is much harder to turn over or to overturn on appeal. A court has abused its discretion if its discretion was affected by an error of law. This is like, oh, it's not the judge's fault. The law is wrong. This is not lawful law. Change it. Or was one which no reasonable jurist could agree. Like the judge was just so fucking wrong. I've been in that circumstance. It's real uncomfortable. Where the judge is so fucking wrong, you're like, how are you this fucking wrong? And I am going to get screwed because you are this fucking wrong. And I can't explain to you why you're this fucking wrong because you're so fucking wrong that you won't listen to reason. It's really uncomfortable as a lawyer to be in that position. Because then you're just like, oh, there's nothing I can do. You're just wrong. Your law isn't lawing. Law and Lumber says, I'll choose a judge that stays consistent any day of the week. Same, because at least you can work around it. You know what they're going to do. They're not going to do anything weird. I mean, it might be weird, but it's consistent and it impacts both sides. So the judge is right here. Fine. The judge is also right in keeping out the notes then. The redacted portions of the article were inadmissible. Well, somebody understands hearsay in this argument. The circuit court properly excluded the contents of the full article that contained the statement because it constituted inadmissible hearsay. It was not necessary for the jury to assess whether the statement was defamatory. I also think truly, in the context of the entire article, that there's stuff in that article that is not good for Depp. This might have been better for them in the long run because there's stuff in the article that supports Amber Heard. For the purpose of the third assignment of error, the court need focus only on the statement that the jury found was defamatory toward Heard, footnote 6. Mr. Depp challenges the circuit court's redaction of all three articles that form the basis of the counterclaim. Although Ms. Heard disagrees with the jury's verdict on the other two statements Mr. Depp made through Mr. Waldman that comprised her counterclaim and does not believe such a verdict was supported by the evidence, the jury did not find those statements to be defamatory. And therefore, any error related to the exclusion of the full articles of which those statements appeared is harmless or irrelevant. Yes, agreed. But we're talking about the one where we're talking about the one we're appealing on. We're not talking about the other ones. Mr. Depp argues that the full text of the article was necessary for the jury because it would have shown the statement was not actionable defamatory comment. It would have given the context to show it was opinion, is what they're arguing. Mr. Depp presents no argument or evidence other than his own conjecture. I mean, let's not throw stones. No, it's exactly what they're supposed to do. I'm just saying. Mr. Depp presents no argument or evidence other than his own conjecture that anyone reading the article would have understood the statement as anything other than a statement of fact that Ms. Heard and her friends lied about Mr. Depp's physical abuse and property damage on May 21st. The fact that the article contained a quote from Ms. Heard's lawyers, additional statements by Waldman on behalf of Depp were factually in nature. That were factual in nature. I was like, I've read this real badly. And references the parties' ongoing disputes does not and cannot remove the defamatory sting of the statement. As the circuit court noted, whether or not the statement is defamatory cannot depend on a third party's decision to put the statement in a certain portion of the article. This is because, as the circuit court correctly ruled, good job, Your Honor. They're like, they don't go nearly as far as Ben Shue does in complimenting the judge. They said the court correctly ruled at the time the statement was made, Waldman did not know what the articles were going to say or how they were going to print the article. So you don't know what other context there will be. So they're looking at the statement when it was made, not the statement as printed. But what's important is Does context make it seem like opinion? But okay. This ruling is not an abuse of discretion. High standard, not going to get overturned on these grounds. It would be stunning if it were. Depp cites no cases that takes the stance he now asked the court to adopt, that the defamatory nature of one person's statement quoted in an article may somehow be cleansed by the statements of others quoted in the same article. I mean, unless you had evidence that he's like, oh, like in a reality TV show when the producers sit down and are like, so-and-so is called this, or so-and-so said this. How do you respond? Then the response needs, or perhaps needs, more context. They're arguing that it doesn't. This ground is not going to overturn anything. Nothing about the rest of the article could have changed the correct determination by the jury that Mr. Depp's statement through Mr. Waldman in the article met the elements of defamation, footnote 7. Similarly, although Ms. Heard disagrees with the jury's verdict on the other statements Mr. Depp made through Waldman were not defamatory, the full articles in which those statements appeared have no bearing on whether Depp is liable for the statement. We know. We're not talking about those statements. Those statements aren't up for appeal. Those statements, he was found not liable. Depp's suggestion that the full articles were necessary for the jury to assess Heard's damages is wrong. The remainder of the article simply discusses fragmented aspects of the ongoing dispute. I don't disagree. And the jury was presented with far more details of the relationship through the evidence permitted at trial. Kind of like the jury had more evidence with Amber testifying than was needed through her doctor notes, therapist notes, medical notes. She testified. That's what was needed. The jury was presented with evidence of the ways in which Ms. Heard had been damaged by the statements both from Ms. Heard herself and from the dueling damages experts. Oh, you agreed there were dueling experts on this part. Thus, to the extent the circuit court erred in excluding the contents of the article that contained the statement, any such error was harmless, which, just so we all know what we're talking about, because we're almost at the conclusion, thank God. Harmless error means that even if there was a problem, you don't overturn it. You don't send it back to the circuit court. You find, yeah, the court might have erred here, but it doesn't fucking matter. It's harmless. It's moot. It doesn't matter. It wouldn't have changed anything. And because it wouldn't have changed anything, nothing is going to happen. We're just going to let it go. And then the court addresses it so that that doesn't happen in the future, even though it doesn't change the outcome of the case. Conclusion, thank God. Heard respectfully request that the aspect of the judgment of the circuit court at issue in this appeal be affirmed. That's an awkward way to say it. Rottenborn. Awkward. Respectfully request that the rulings of the circuit court be affirmed. Great. Great. Let's go on. Let's move on. 12K here, I know. Don't forget to give the amazing Emily a like. Look, it actually matters. YouTube makes it matter. It actually matters. The likes matter. The comments matter. The engaging in the live stream and commenting and chatting in the live stream matters. The members have realized and know that they are not subject to the slow mode. So if you hate slow mode, you can always become a member of the channel. Those start at $2.99 a month, and you get all those fun little perks. There's also a membership over at Law Nerds Unite at lawnerdsunite.com, which has some additional perks. But if you like the YouTube perks, the YouTube stuff is here. So do the YouTube things, the likey, chatty things. We have a whole lot more to get into. We're going to get into these Amicus briefs and Ben Shu's response to the Amicus brief. So I'm going to swoop. We're going to be here for more than 2 hours because we're doing this until we're done. And I know there is a whole motion hearing going on in the Murdoch case. Maybe we'll just respond to it on Tuesday. Maybe that's just what we do on Tuesday. I'll ask you guys if that's what we do. So with that, let us continue on. And if you guys haven't seen, we're going to plug one more thing. If you guys haven't seen the Emily Show podcast this week, it gets into the real tea about the Erica Girardi scandal earrings that were sold and whether or not the scandal earrings are the ones that they're purported to be. Yeah, it's real interesting stuff. So that video is here for you too. And it's time to go. Question, why was Elaine's name on the answer? It wasn't. It was only Rottenborn's name on that. Let me pull it back up. This is the reply to Depp's appeal. And this is coming from Rottenborn's firm. This is a different Elaine. This is not ECB, Elaine Charlson Bredehoff. This is not her. This is a different Elaine that works at Wood Rogers, which is the law firm where Rottenborn is, and this is signed by Rottenborn. So wrong Elaine. All the Elaines are like, it's ruined forever. It's ruined forever. It's ruined forever. So no, different Elaine. Hopefully that helps answer the question. I'm also, before we swoop over, I'm going to get to a few super chats just because otherwise we're not going to get to all of them when we get to questions. Jen said, hey, EDB, hello. I love going by my initials. We'll be in your neck of the woods at the Supernatural Convention next weekend. Let me know if you want an autograph or something while I'm there. Thanks for being awesome. I forgot that was coming. I need to take a look and see if there's tickets available. I might show up. I might just have to come. But thank you, Jen. I will definitely let you know. If you guys are ever coming to Nashville, there are some things that I love here in Nashville. Frothy Monkey is one of them. I absolutely love, even if you just go to the liquor store and pick it up, there is Tennessee Legend whiskey and Old Smoky whiskey aplenty. Love it. I love, well, I should keep that top secret. We're going to keep that one top secret. That recommendation will keep top secret. But Frothy Monkey is absolutely one of my favorites. And so is Big Bad Breakfast, BBB. My husband always wants to call it Big Ass Breakfast. Big BBB is fantastic. They, each location is locally owned, but they are a franchise. So there are some elsewhere in the South. They are so good. So good. Julia said, Lawnard baby arrived post Friday. Me and baby Lawnard are listening and napping. Congratulations, Julia. Get lots of rest and squeeze your little Lawnard. Congratulations, congratulations, congratulations. Danny, I'm so happy for your PTO. Stina, I know we answered that one about Mandy Matney. We will try. I will ask for sure. All the family law attorneys are just sipping tea like, Yep. Question, any updates on the Warhol case? I'm going to get to that during Q&A, Samantha, but I saw it. Can you explain what an amicus brief is in terms of 5-year-old might get? People who have an interest in how the court rules for their own purpose. I'm still confused. Hopefully that clarified it. How did Wellman's statement made in a UK paper get allowed into a Virginia counterclaim initially? I might have missed that part of the saga. He made the statement. Well, the counterclaim is under the purview of Virginia. I did not look and see if they litigated whether that was proper or not because it was combined, but he would have been in the US when he made the statements. But I don't know if there was much litigation pre-trial on that. I would have to go back and look. Jamie said, Emily, my wife and I love your channel. She's actually a producer for Pokemon. Jamie, tell me everything and tell me more. I love Pokemon. The way that I am gripped playing Pokemon Scarlet right now is when y'all are like, Emily seems behind on content. Yes. I also love Pokemon. I love Pokemon. I love that your wife is a producer for Pokemon. Do you mind giving a shout out? Shout out Pokemon producer Emily. Shout out. That's amazing. Real Laura B. Hey, good to see you. Clarifying things in the chat. First officers saw no wine or damage. Later, Isaac arrived and saw a puddle of wine. We heard that from Isaac. It had been cleaned up when the second set came. A discoloration is barely discernible in the body cam. Well, so the timing might not be the whole thing, but the timing, truly to me, watching the trial, the timing was not clear. Stephanie said, so he's guilty for defamation for lying the same way Amber Heard did, so that both verdicts would make sense. Stephanie, I think that's the way to read this motion. But Laura, thank you. Your knowledge of this case is so in-depth. I very much appreciate it. Don't they have to prove it caused her to lose work? They have to prove it caused monetary damages to justify the $2 million, and they're arguing no. So that's where we're at. Paige said, will the judge be able to call all this contradictory explanations like you are? They will focus on the things that matter to their decision making, and they will focus on, well, some of it. Yeah. I mean, that's what their brains are trained to do, is to parse it. They also have research attorneys that are going to help them parse it. So yeah, but some of this is, okay, well, that's your argument. They're much more used to it than I am. Appellate stuff is not my favorite. Let's go to amicus briefs. We're doing it. There are amicus briefs, and then there is a omnibus response to amicus briefs. These are friend of the court briefs. Look, the court might accept or might not accept. These have to be submitted before Amber Heard's brief. Let's actually see if it was submitted before Amber Heard's brief. This is the amicus I'm looking at. 12/6/2022 at 12:49 Eastern. Let's see when Amber's brief was filed. We have not gone over the precipice or the precipice. We are going over the precipice of sanity now. We have not done that yet. We have not gone over the Precipe Amica brief yet. Yes, it's amicus. Some people say amici. There are other ways, not like Avicii, but there are other ways to pronounce it. I always pronounce it amicus. It's just how I pronounce it. So this was submitted on, this is Amber Heard's brief on 11/23. I think there was another amicus as well that I have somewhere. I just don't know where it is. So there were two. Oh, here's the other one. This one was not, this copy I have is not stamped. So there's two amicus briefs. Let's take a look. We are not doing a deep dive on the amica briefs. We are not. We are not. We have gone over the precipice. We are not doing a deep dive on the amicus briefs. I'm going to zoom through what they say, and then we're going to go to the response to them because we do not have time to go through all of this. And I've already heard enough about these briefs to not be thrilled with them. Opening brief of the amicus curiae, amici, in support of the appellant Amber Heard and reversal of the judgment. These attorneys, one from Redondo Beach, California. What up, South Bay? And then one from Arlington, Virginia. Did that say, I read that as Antonio Sabato. I'm sorry, Antonio. It was an Antonio and an S, and my brain filled in the gaps. Let's see what their arguments are here. Identity and interest of the amicus, source of authority to file, introduction, the publication at issue, the Washington Post op-ed, other negative publications about Mr. Depp. I don't know why that matters to the amicus. Depp's unsuccessful British lawsuit against The Sun. I don't know why that matters to the amicus. The Depp v. Heard trial. That matters. Post-verdict information. What? Abuse can refer to many types of actions. I don't know why this is in an amicus brief. Intimate partner violence is a significant problem in Virginia and the U.S. Okay. I mean, yes. But okay. Nearly a quarter of female victims of intimate partner violence do not report the violence because they fear reprisal. Okay. I mean, they're trying to give the court more information outside the case, but I don't know why that information means that the court did wrong things or means that this verdict standing is a problem, because this is a defamation case. I mean, I can imagine what they're arguing is that are they going to argue that victims will be silenced for fear of defamation cases? I mean, it's particularly true when we look at things like the Harvey Weinstein case. Like the fear of how the public will respond is a very real thing, but it happens in all kinds of lawsuits. Okay. The verdict in the present case communicates that retaliation in the form of defamation action is a powerful weapon against women who report abuse. Okay. Summary of argument. The trial verdict is inconsistent with the First Amendment. You know, it's interesting because Amber Heard did not argue that at all. Look, you can't lie. The jury found that she lied. That's what that is. The trial court should have ruled that Ms. Heard's op-ed was protected speech. Wrong. Ms. Heard's op-ed was protected opinion. Did it sound like she was stating an opinion? Abuse in the op-ed was subjective. The alleged abuse defamation was not based upon facts that were verifiable. Either she was abused or she wasn't abused 2 years ago. I mean, but here's the thing. I think Amber Heard's attorneys could have done a better job with this. I think Amber Heard blew that out of the water. If they had argued, and they didn't go with a technical legal argument, but when I first started covering this case, I said, here's the thing. Here's the technical legal argument. 2 years ago, I became a public figure representing abuse, domestic abuse. A okay, focus on not whether Depp abused her. Don't argue whether Depp abused her. Argue whether she became a public figure representing abuse. Argue that. Focus on that. Prove that. They didn't. What they sought to prove was that the abuse happened. They sought to prove that abuse happened, not that she went into the public to talk about abuse happening, not the length of hey, I did these speeches and these talks and these charity works. I was a public figure. I became a public figure. These photos, this happened. Focus on that. They didn't. They focused on proving he abused me. So the jury was also focused on, did this abuse happen? Not whether or not she was a public figure. If you wanted to split hairs, it's a completely different trial strategy. But my opinion is that Amber Heard did not want to split hairs. She did not want to say, I am correct. What I said is literally true. I did become a public figure representing domestic violence. It was not my intention. It happened. I went to court. I made this statement, and then it became a thing. And I leaned in. They didn't want to do that. I think Rottenborn probably wanted to do that because I think that's a winning strategy, though it is a nuanced strategy, which can be hard with the jury. What they wanted, my opinion is that Amber wanted to prove he abused me and run all of the details in court. That's what I think she wanted to do. They did not take a nuanced approach to this. Rottenborn argued it in his opening, and if they had taken that case, I think they would have won. She wanted the details out there, is my opinion. And they fought it that way. And the second Elaine got up and started saying she carried this compact around in her purse her entire relationship because she needed makeup to cover bruises, her entire relationship, the nuance was out the window. Because they argued not that she became a public figure representing domestic violence, but that she was a victim of domestic violence. And that became the argument in front of the jury, not the nuance of these statements are literally true. And Depp's team went a long way to say, though these statements might be literally true, they leave a negative connotation because if it's literally true that she became a public figure representing domestic violence, the connotation, the defamation by implication is that Depp abused her because she put in 2 years ago. And if she hadn't put in 2 years ago, then Depp can argue, hey, it's an implication. And she can argue, hey, I'm not implying you. I'm not implying you. They would have a lot more room. But that's not what she did. And the nuance got lost. Rottenborn tried real hard. And this is why I thought if there was a statement that was going to be the easiest for Depp to win, even though I thought this was an uphill battle all the way, if there was a statement that Depp could win, it was going to be on the headline. Because her stories changed so much with regard to that. But the jury threw it all out and said, no, none of that's true. And then the implication is negative and therefore defamation. Statements made in the op-ed cannot be the basis for finding actual malice. Who would have known but her? No defamatory facts could reasonably be implied in the op-ed. This is the literal true defamation by implication. Republication of the headline written by the Washington Post staffer cannot be the basis for liability. I just fundamentally disagree on the law. Mr. Depp provided no causal connection between the op-ed and any alleged injury. Okay. The trial court should have dismissed this action based on comedy. Don't bring this argument to me again. Don't bring this argument to me again. Don't bring this argument to me again. Fuck off with comedy. Just fuck right off with comedy. It's a different court system in a different country with different fucking parties. There's no comedy here. Stop trying to make fetch happen. There are legal arguments to make. There are nuanced arguments to make. But the reality of the situation is that the jury didn't believe Amber Heard. And arguing comedy isn't going to fix it. It's not going to undo it. It's not going to fix it. But I guess they're just... Where is the heading that says the jury's all full of misogynists? I don't see that heading in here. I'm waiting for that argument to be made, though. It's got to be in here somewhere. Let's take a look at what the other... I'm going to look into some of these points in just a second. I want to see if there is a... Does this other amicus have a... Let's see. Amicus curiae in support of appellant Amber Heard and reversal of the judgment, although Amici, although Amica, do not believe the assignments of error are required for an amicus brief. Amici provide information as to which arguments apply. This is just their precipice. All right, this is just the like, hey, we don't need that. Okay. Let's go through this a little bit more. I just want to see why they're interested, and then we're going to go to the response. Case law. Virginia statutes, other authorities, the ACLU Artist Ambassadors Project. Okay. A slap in the face to free speech, protecting survivors' rights to speak up in the Me Too era. These are interesting because that's going to be about slap motions. Slap doesn't apply quite here because Virginia. U.S. Department of Justice, Bureau of Justice Statistics, police response to domestic violence cases. Okay, so we've got statistics on domestic violence. Slapping back recent legal changes in the application of the statute anti-slap laws, or the state anti-slap laws from the ABA. That I'm actually interested in. Anti-slap is a really interesting area of law, and there's arguments for and against strong anti-slap. Virginia uses anti-slap differently. Anti-slap, slap and anti-slap, just as an aside. As an aside, slap and anti-slap. SLAP stands for strategic litigation against public participation. Like, hey, you're writing a book about a politician, and that politician is like, I'm going to sue the ever-living fuck out of you if you publish that book. And with that, I'm being told my sound effects are too low. Is that better? Did I mess with my soundboard? I might have messed with my soundboard. There we go. That might have been a little too loud. So, strategic litigation against public participation. In some jurisdictions, this comes first. We covered this with Ethan Klein, the H3 podcast, and Ryan Kavanaugh, who may or may not look like Harvey Weinstein. And in that case, when you file the slap motions, you don't get to go to discovery. It yeets the entire litigation first, all of it first. So the litigation can be resolved when someone is trying to silence someone from using protected speech. Hey, this is protected speech. I'm allowed to say it. And in the H3 case, it's like, hey, this is comedy, parody, mockery, and it's literally true. And we can prove it's literally true. So the slap stops the lawsuit before it even goes to discovery. If the Depp Heard case had been in California, not Virginia, at the beginning, I think you would have had a huge problem because you wouldn't have had all that ACLU discovery. And I think this case could have gotten yeeted on an anti-slap. It stops the litigation from going forward. In Virginia, the anti-slap is a defense later, and the court found it did not apply here because this is an intentional tort. So this is intentional defamation. Anti-slap is not a defense. So sometimes anti-slap cuts off the litigation at its knees before it even starts. California and others. Sometimes it's a remedy, a defense that you bring at trial. Sometimes there isn't anti-slap. Like there are some jurisdictions where anti-slap literally only deals with government. It doesn't deal with individuals. It doesn't deal with defamation. It doesn't deal with free speech like this. The arguments are sometimes when you've been defamed, you need the discovery to prove it. And anti-slap does not give you that opportunity in a lot of jurisdictions. So there are arguments, pros and cons. The pro in California is if you are being sued for defamation, you can prove your case before you spend millions of dollars litigating it. But for the person suing, you better have your evidence before you go to court, because if you don't, it could get yeeted. Excuse me. So anyway, slap is interesting. Table of media publications. Is that why this is so long? The backlash against Amber Heard follows a sad, predictable pattern. From Complex, June 6, 2016. Advocates fear Depp Heard trial will have a chilling effect on women coming forward with abuse claims, from PBS NewsHour. Amber Heard opinion, a transformative moment for women. Oh, the op-ed issue. Amber Heard, I spoke up against sexual violence and faced our culture's wrath. From the Washington Post. That's the online version. Why do you need both? Whatever. Johnny Depp's playbook won't work for most men. New York Magazine, The Cut from June 10th, 2022. So after trial. Johnny Depp and Amber Heard trial. How many viewers gathered on YouTube and how it was discussed on Twitch. Stream charts. Oh, I'm actually interested in that. Dan Wooten, gone potty. How can J.K. Rowling? Oh, that's the UK article. Marilyn Manson files defamation lawsuit against Evan Rachel Wood over rape and abuse allegations. NBC NewsHour from March 2nd, 2022. Men always win. Survivors sickened by the Amber Heard verdict from Rolling Stone from June 1st, 2022. This is just all of it. There's a whole lot. Johnny Depp, quote unquote, wife beater libel trial enter final days as lawyer calls allegation career ending. Watch live as Amber Heard's second day of testimony at Johnny Depp's defamation trial continues. The Independent. Slap lawsuits pose threat by intimidation. Johnny Depp's lawyers, Camille Vasquez and Ben Chu, pose for pictures with alpacas. YouTube. Okay, wait, we're just...
Camille, have you seen the alpaca?
From Law and Crime. I mean, they want the court to be like, the lawyers are posing with alpacas. The lawyers are posing with alpacas.
Have you met them?
Have you met the alpacas? Have you met the alpacas? Wait, I don't see them posing with the alpacas. When do we pose with the alpacas? All right, I'm scrubbing. Okay. You guys, this should be overturned because they posed with alpacas. I'm being facetious. These lawyers must be so tired.
Sorry.
I'm going to turn this down a little bit because this is just background noise. I remember the alpacas. Okay, we need to speed this up. Wait. Where's my zoom? Playback speed. Ben Chu took the picture. He's not posing with the alpacas. He's getting the photo cred. Great. After a very long day at work, they get to pose for pictures with alpacas. And this dude's asking if Camille Vasquez is the breakout star of the trial. Hold on. Let's go back to regular speed. Is this a problem? Why is this a problem for the appellate court? The appellate court doesn't give a fuck if Camille Vasquez is posing with alpacas. She's like, Camille's face says that's fucking weird. Why is anyone obsessed? I would like to do my job. I'm exhausted. I have to get up early to get my hair done every single day to be in trial. And this is all kind of wild. I'm just trying to do my job, man.
Saying that you are the breakout star of this trial. They're saying you're the breakout star.
She responded none and took a picture. She awkwardly laughed because, we're women and that's what we do sometimes. It's like, no, thanks, I'm good. She awkwardly laughed, smiled, and took a picture. She's doing nothing inappropriate. And she needs to try to leave the courthouse, and their car wasn't there yet. This is the car that just arrived. Okay, so why does the appellate court give any fucks? How many fucks does the appellate court give? Zero, none. Okay, we are back to this brief. I couldn't help myself. I was too curious. Okay, I want to look at the other thing that I was curious about, and then we're going to get into, just a little bit of this before we get to the response. But we're gonna all go with the stream charts news. What is stream charts? I've never heard of stream charts. Have you all heard of this? Mr. Upper Torso, Amber Heard is just jealous. Maybe she is. She felt upstaged by the lawyers. This was her moment. Johnny Depp and Amber Heard trial. How many viewers gathered on YouTube? Well, I can tell you. Do you guys want to guess? Hey, some of you might know this. Why don't you all guess in the chat what our max number of concurrent viewers were throughout the trial? I actually know this number. Give me a guess on what you think our max concurrent viewers were. Some of you might know. We'll see. Miguelina, if you see one that's in the right range, will you flag it? Because I know how many we had. Let's see. I'm curious about what this is. So I see some of you guys are right. Some of you guys are a little high, but I like it. I like it. I like you getting high. That's going to get clipped. Max concurrent viewers. We definitely did not have 3 million maximum concurrent viewers at one time. It was in the hundreds of thousands. Miss Lee, I like 800K. It wasn't there. We'll get there. We'll get there next trial. Our maximum concurrent viewers. 350 is very, very close to our maximum compute viewers. Oh, 365 is even closer at max concurrent. You guys are very close. We maxed out at max concurrent viewers over 370,000 max concurrent viewers. We're not law and crime, folks. We were not over 1 million. We're also not whitelisted on YouTube the same way they are, but I have issues with that. I love it. You guys, a lot of you were very close. I'm ready for 560. I received that for our next trial. I received 500K for our next trial. I receive it. We're doing that. 372, very close. So yeah, we were at over 370,000 max concurrent viewers for our highest stream. June 1st, District Court of Fairfax County, Virginia announced a verdict on the most scandalous Hollywood lawsuit of the last decade. I mean, the trial between Johnny Depp and Amber Heard has made an extraordinary residence in the society. And attracted a huge audience. The trial was broadcast on YouTube. It was streamed on YouTube. And its fragments spread across the web in forms of memes and funny video compilations. Many even dubbed this case the TikTok trial. We weren't a part of that. Stream Charts collects data of viewership statistics, the popularity of the court broadcast on YouTube, and the number of mentions in Twitch chats. Streaming happens not just on Twitch. Johnny Depp has filed a claim for damages. How many people watched the trial? This is what I want. In 6 weeks, the broadcast amassed a total of 83.9 million hours watched, with 3.5 million peak viewers during the announcement of the verdict. Where was that across all of YouTube? Or is that across all of everywhere? The first 3 days of trial at which Johnny's friends and family testified gathered only 600,000 hours watched, with only 41,000 peak viewers. However, as soon as Johnny himself began to testify in court, the number of watch hours increased by 4.5 times to 2.7 million at the peak. How do you... Oh, mention channels. Look at us. Wait. That's us. Why are we mentioned? Why are we mentioned? What? We're mentioned above law and crime. We're mentioned after Asmongold and XQC. Right, because we're the YouTube streamers, not Twitch streamers. This stream chart is week 1, week 2, week 3, week 4, week 5, week 6, week 7. Are they breaking it down? What's with the pink and blue? Are you breaking it down by plaintiff case and defense case? Are you gendering the plaintiff case and defense case? Is that what's happened here? Is that why this is pink? This is verdict. Okay, whatever. I'm just trying to understand the chart. I think that's what they're trying to say. No, these are week 1, week 2, week 3. What's the difference between the pink and blue? YouTube versus Twitch? But why make it pink and blue? And why put Amber behind this one and Johnny behind this one? What is this chart? Stats from Law and Crime Network channel. So these are just stats from Law and Crime? Is that all they looked at? I don't understand your chart. This is the week of April 10th, 17th, 24th. What are the two? I'm confused by their chart. Look at the chart titles. I'm trying to. It just says stream charts. All right, let's go. It just says stream charts. And it doesn't break down well what it is. This just says stats from Law and Crime Network channel. But it doesn't tell me the difference between April 10th here and April 10th over here. Peak viewers. It gives me no indication. So, hours watch versus peak, top left corner. I see nothing. I see nothing in the top left corner. I'm missing it. But peak viewers, average viewers, hours watched. I don't know. Upper left corner on the graph, hours watched versus peak. Hours watched is blue, peak viewership is pink. I'm clearly missing it. You guys are like, it's as plain as day. It's as plain as day. I don't see it. So thank you all. Hours watched versus peak viewers, fine. It's not a great demonstrative. It's in the top of each chart. Oh, peak, there we go. Peak viewers, hours watched. I couldn't see it at all, which means it really is not a good demonstrative because I lost this context because that is not bold enough for me to see. Thank you guys. Y'all found it. Hours watched, peak viewers, great. During the third week of trial, Depp had provided as evidence the testimony of the housekeeper who stated Miss Heard behaved like a spoiled teenage, I think he said spoiled teenage child. I don't think this is a direct quote. Miss Heard behaved like a spoiled teenage child and drank 2 bottles of wine a day. This is not a direct quote. This is not a direct quote. Don't put it in quotes if it's not a direct quote. This isn't a direct quote. Blah. These are different responses to different questions. He said things like, but you can't put it in quotes if it's not a direct quote. That's not a direct quote. That's a fake quote. Fake. He said both of those things, but not in that way. And not in succession. That was not one sentence from Ben King, who also was a house manager who provisioned the house. I'm not going to keep arguing about this. The number of hours watched of broadcasts of the third week was about 9 million hours watched. At the beginning of the 5th week of the hearings, Amber Heard's side presented a photo confirming the physical injuries. At the beginning of the 5th week of the hearings, Amber Heard's side presented a photo which they contended confirmed the physical injuries she allegedly received from Johnny Depp. The number of hours watched increased to 18 million. Are they trying to make I didn't realize this was going to be a breakdown of this goddamn chart, but here the fuck we are. Here the fuck we are. We're pulling this apart first. Because there's a whole lot of assumptions. There's a whole lot of assumptions. A whole lot of assumptions. They're trying to correlate it seems to me that they are trying to correlate a graphic photo and the watch increase. I think the watch increase had to do with now everybody's talking about it and people kept talking about it. So the trial was gaining popularity and people were like, oh, we're going to keep watching this. The final week of the trial became the most popular, exceeding the watch time previously set. And again, I think that's because everyone's talking about it. This is interesting. Mentioning the trial in Twitch chat. Trial is blue. I don't know what just happened. Oh, I made it bigger. Trial is blue. Johnny Depp is, these are the I guess the words that are mentioned. Trial is blue, Johnny Depp is red, Amber Heard is yellow. And then they've got the peak of those words being used. That proves what though? The verdict, Johnny Depp outstretches everything. Over 20K mentions in the chat. This is like to the moon. This goes well beyond 25K. But yeah, he won, and that was kind of staggering. So of course that's being discussed. I'm shocked that I'm here. Like, that's not what I was expecting when we came here. I'm surprised. Let's go to the YouTube trial broadcast. The most popular YouTube trial broadcast. Depp v. Heard, Law and Crime, Other. Hi. Apparently I'm other. It's okay. That's okay. This goes day by day. Is Law and Crime not on the chart every day? I guess. Vietnam football national match at SEA Games. Are these people watching football? What the fuck is happening in this chart? Ligma MX football. Was that going on at the same time? Did other things happen during this trial? What are they talking about? Depp v. Heard, Law and Crime Network, other channels. What other channels? This chart is not giving scientific verification. My name's in there. Would they call me a blogger? Stream charts, whoever you are. I'm not a blogger. That would imply I write things. But I've jumped ahead. I'm sure you're not going to have a conversation with me after this. From April 12th to June 1st, the Law and Crime Network channel was the leader among YouTube channels. Let's talk about how YouTube whitelists channels, but that's another conversation. For 10 days, and the number of concurrent viewers reached 3.5 million during the announcement of the verdict. Yeah, on Law and Crime it did. In addition to the trial, there were several other channels that were quite interesting to YouTube users. Oh? In particular, the VTV, the Tao channel with broadcast of football matches of the Vietnam national team and the SEA games reached 1.1 million to 2.5 million peak viewers. Are you trying to say that... What? Are you trying to say that what? Are you trying to say that football was more popular than the trial or vice versa? Are you... I don't understand. There were several other channels that were quite interesting to YouTube users. Football. Okay. What the fuck does that have to do with anything? No, I know they mean soccer, but I don't understand what that has to do with anything. Like, why is that here? During the time the trial was more popular than soccer. Okay. All right. In addition, many well-known streamers actively observed the court. Among the top creators on Twitch, one can name Asmongold and XQC, and a well-known lawyer and blogger, Emily D. Baker, covered the trial on YouTube. I'm not a blogger. I'm a streamer. Not considered for the streamies because I don't stream games, but thank you. I think I did. I think we did. They forgot the D. It's disrespectful at this point. She needs the D. Leave it there. I'm so fucking confused. Observed. I don't know what's happening with all of this. I don't know why it says observed. I normally don't catch typos, but I think there's supposed to be a V in there somewhere. We didn't observe. We commented. We provide commentary. It's also a scandal. I'm definitely not a blogger. Scandal. Stream charts. We can have a chat. I have no idea what you're talking about. Depp heard the Depp versus Heard, but wait. Does this mean we're part of the Amicus brief? Because we're mentioned in the chart. Does this mean we're part of the Amicus brief? Is this why the Heard stands come for me? I thought we were tremendously fair with this trial coverage, but it's like, I love that it's Asmongold, XQC, and EDB. Let's just speak it into the universe. We're just coming for the streaming titles. We are part of the Amicus brief. There we are. I don't understand the comparison with soccer. They didn't make it clear why they were comparing. They didn't even say the trial outstripped traditionally popular content. This content is normally the most popular live stream content on the platform. They didn't tell you why this was here. But I think this means we're part of it. We need to start keeping a list of how many lawsuits were mentioned in, because the channel's been mentioned in a few lawsuits. Which always becomes like Inception. Does this link to my channel? No. What? Wait, what is this link to? Wait, you can pay for things? What am I supposed to pay for? What is this supposed to tell me? I don't understand what the link goes to. But does it? I don't know what it goes to, but it links me to pay for something. If you link to XQC, does it do the same thing? I'm guessing it does. Does it link to my... Oh! It links to XQC's Twitch stats for the past 30 days. That's interesting. Wait, it doesn't link to my stats. I have to pay for my stats? Do you know it's me? You can't possibly. Wait, do we get Asmongold's stats? Fascinating. I wonder if it's easier for them to link to Twitch. I wonder if that's just an easier way for them to do it. That's really interesting. Well, I don't stream on Twitch. I make it difficult for everybody. I wonder if it's just easier. Where does this link to my YouTube channel? No. They're like, fuck no, we're not linking to your channel. This is supposed to link to some kind of stats. I might pay for it just to find out. Not right now, because I think that said $300. Did that from $300 with data from 15 million channels. Oh, from $9. Okay, we're going to do this later. Otherwise, we're never going to finish streaming today, but I'm very curious. I mean, though I can see my own stats on the back end of my channel, so I don't really know what I need this for, but that's very interesting. Wait, do we get the stats for long crime? Nope. You got to pay for the YouTube stats. All right, I'm done. Twitch just has a better API stats than YouTube. I bet they absolutely, Twitch has better API stats. Twitch has more accessible public statistics. YouTube shut that down because of Dramageddon. YouTube did shut down a lot because of Dramageddon when people were watching subscriber counts fall. Oh no, I know I'm on Social Blade. They didn't have the D, so they can't link. That's exactly what it is. 300 per month. I think that's enterprise. Emily found a rabbit hole. Yes. Yes. But that's interesting. I had no look. This is a first look for me. I had no idea what we would find with this chart. I just wanted to see what the chart said. They've linked this chart in an Amicus brief to try to make a point, and these charts don't make a point other than a lot of people watched, and people also watched soccer. What the fuck? What the fuck is this chart? I mean, okay, people watch this trial. They also watch soccer. Great. Ooh, wait, there's an article on how Pokemon Scarlet Violet took over Twitch. I need a gaming channel. Okay, stop. Emily, go back to the appeal. Go back. Go back. Go back. Go back. Go back. Oh, Lord. All right, well, let's pull up this link to the Washington Post just so we have it. This article was published more than 4 years ago. Here's the editor's note. This was found defamatory. Oh, there's a continue on editor's note. So just so we have it for reference, so we have the digital edition for reference if we need it as we go down the road. Let us continue on. I'm not going to pull up any more of these references. That chart did me in. I was hoping for information. And what I found was sometimes people also watch soccer and my name, which was interesting. La Liga. I did that badly. Apologies. I did that absolutely badly. Okay. Let's see. What you need to know about ACLU artist ambassadors, including Amber Heard from May 18th, 2022. She's still an ambassador with the ACLU? I mean, the ACLU's testimony was the most embarrassing testimony at this trial. It was wild. Emily's gaming channel will get so many subscribers so fast. I don't know about that, but I'm tempted. I'm very tempted to have a gaming channel. Identity and interest of the amicus. Yeah, this is all that we want to know, and then we'll move on. The entries identified in Appendix A. The entities identified in Appendix A. And we're going to have to go to the appendix already. Mackenzie, when I get to questions, we'll talk about it. We've definitely been mentioned in a few. We've not been sued, but we've been mentioned in like as this and this and that. You guys are really like, we want a gaming channel. All right, Miguelina, will you put up a poll? I can't promise I'll be consistent. Do we need a gaming channel? I think it would be fun though. I was watching the Gaming Awards last night while chatting with friends, and there was a preview for Party Animals, and I'm like, I want to stream this game. I don't know when this game is coming out, probably March. I want to stream this game. I want to stream this game immediately. It looks so much fun. And then I want to, we could do some Law and Order Among Us. The entities identified in Appendix A who have signed on to this brief fall in 3 categories. Oh God, there's 3 categories of amicus. First, organizations that support a vibrant First Amendment and have joined to protect their ability to engage in reporting facts and opinions regarding important current issues, which is threatened by the verdict in this case. What? Emily D. Gamer. Emily D. Bad Gaming. What? How does this opinion threaten those who are interested in reporting? This opinion attacks reporters none. Reporters weren't sued. The Washington Post wasn't sued. The speaker was sued. The person who said the shit was sued. If anything, reporters should be happy. Look, this is the way it should be. Don't sue me for reporting it. Sue the person who said that it was true before it was reported. They should be happy with that result. Second, civil rights and women's groups who have joined to address the significant diminution of reporting of abuse against women as the result of this verdict. Reporting of abuse has always been an issue. Always been an issue. It's not just an issue because of this verdict. That's my experience. Third, groups assisting persons who have been abused, especially involving intimate partner abuse, have joined to protect their clients from the devastating effect of this verdict. I struggle because I think the narrative that this verdict damages victims of abuse is itself damaging. I think that narrative is damaging. Source of authority to file. Well, who are you? And why do you have 3 different interests? Generally, you get an amicus that has one interest. The Onion. We do parody. Don't fuck with that. This is not clear. Where's Appendix A? Get me the appendix. Oh, wait. I can Control F myself. Ha. Please call it Appendix A. Why isn't the appendix called the appendix? Oh, it's App A. Ugh. It's annoying. It makes it hard to Control F to where I'm trying to go. If you don't... Because do you see how many times it says app? Wait, no. It's not under App A either. What the fuck did you call your appendix? I'm already annoyed. Where is your... How many pages is this thing? Oh, here's your conclusion. All right, well, maybe we'll do the conclusion first and save ourselves the heartache. Where's your appendix? Oh, it's not here. I didn't download it. I further certify this brief does not exceed the longer of 50 pages or 12,300 words. Okay. They sent it to all the lawyers. Great. I'll go find the appendix another day. The trial in this case was not about any defamatory statements made by Miss Heard. This is the conclusion. This is the conclusion. The trial in this case was not about any defamatory statements made by Miss Heard within her op-ed itself, but rather was a vendetta for all of the publicity surrounding the allegations of abuse by Mr. Depp from the date that Miss Heard sought and obtained a temporary restraining order in May 2016 up until December 18, 2018. Okay, in a generous light, the trial is not I wouldn't say vendetta, but the publicity is the issue because that's the damage of the defamatory statements, you see. So the publicity, if it's based on a lie, is the that's where the defamation is? In it being published. So the defamation trial is about the publicity surrounding the allegations of abuse. Depp said they were false. Heard said they were true. The jury said Heard was wrong and they were not true. And there is a defamation trial. You made allegations of abuse. I say the abuse didn't happen. I'm going to a jury to say that's defamatory, and that's where we're at. This is exactly a case about defamatory statements. This is not a case about defamatory statements. It's a vendetta for all the publicity about the allegations that were found to be defamatory. They're saying that the damage happened before, they're trying to pin the damage before the UK case. A defamation lawsuit based upon this op-ed was not a legitimate vehicle for remedying Depp's dissatisfaction with how his career has developed, how his marriage ended, and the negative publicity he has received, much of it warranted by his own actions, as evidence excluded would have shown. Oh my. Oh, this thing is going to be charming, isn't it? We'll do the statement of facts and then we'll have to move. Well, no, we've got time. Is their conclusion he deserved it? Is that the conclusion? The conclusion is he deserved it. Okay. This is the amicus supporting Amber Heard. He cannot seek retribution for the allegations that were made in the California courts regarding his alleged physical abuse of Miss Heard. You know, it didn't come in at trial. Anything about the allegations made in the California courts. You know what came in at trial? Amber Heard staging a photo op outside that California court. That came in. That came in. He cannot seek retribution for allegations that were made in California courts. Also, things said in court can't be defamatory. And it didn't come up. And subsequent publicity from various venues, including The Sun, which he sued. Defamation by implication is a limited doctrine that does not allow a litigant to rehash dissatisfaction with public coverage from years ago from all sources. But she published an op-ed. The doctrine further does not allow the claimant to twist the meaning of the words in the publication that is alleged to be defamatory. You know who stops the twisting of words? The jury. Because if a jury finds that you are twisting the words, you know what they're going to say? Yeet. 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 If you are exceeding the plain meaning of words like broken nose, and the jury's like, I understand what a broken nose is. And then they look at the pictures and they go, oh, you're on the James Corden show. That doesn't look like a broken nose. They're going to find that the meaning of the word has been twisted and they're not going to side with you. But what defamation by implication allows for is when the implication of a thing is defamatory, you're allowed to seek redress for it in the courts. But apparently you're still allowed to be slammed in the court of public opinion, which is weird. But where we live now. The doctrine further does not allow for the claimant to twist the meaning of the words in a publication that is alleged to be defamatory. Well, the jury found it was defamatory, so we don't need to say alleged anymore, but you're this amicus, it's fine. When evidence establishes that a defendant has a subjective basis, considering their vantage point, for the statements they have made, actual malice cannot reasonably be found. The jury found that there wasn't a subjective fucking basis, though. You missed the point. Twisting words like pledged, perhaps. You are missing the point. The damage that will be done if the verdict is upheld. Question. How do we, the supporting law nerds, file an amicus on behalf of Depp? It is too late. That ship has sailed. His opening brief is already in. So it is done. Depp, and again, we don't have an interest in the Depp verdict. Truly. Speakers might, the ACLU at one point might have saying, hey, we have an interest in allowing people to protect their liberties like the First Amendment by saying the bounds of the First Amendment do not include defamation. The damage that will be done if this verdict is upheld to the First Amendment, to First Amendment jurisprudence, the ability of Virginians to express their opinions. This wasn't an opinion. And the ability of women to report domestic violence for fear of retribution and an expensive lawsuit would be no less than catastrophic. I don't see how the First Amendment is damaged. There is a huge issue of fear of reporting domestic violence because people aren't protected when they report domestic violence. And it's not that they're not protected by an expensive lawsuit. It's that they're not protected by restraining orders, and there aren't enough law enforcement officers to protect them. Restraining orders do not stop people from being harassed, threatened, killed. It doesn't. There aren't enough resources. I completely agree. But that's not this case. I don't think the number one fear of most victims of domestic violence is that they're going to be sued. I think the number one fear is that they are going to be further harmed and they cannot get away. That they don't have the resources to leave their abuser because their abuser controls their finances. That there is nowhere safe for them to be. Those, I think, tend to be the largest fears, which if the amici are who they say they are, they would know. For these reasons, the amici respectfully request that this honorable court reverse the judgment against Ms. Heard with instructions to dismiss all of Mr. Depp's claims. That's not going to happen. They're not going to just dismiss. That's not going to happen. Let's look at but we don't know who the fucking amici are because there's no appendix. Like, where is the appendix? If you're going to put in we need to know who you are and how you're actually interested. I don't think you're actually interested. Kate Go said, women will be afraid to report DV because another woman was proven to lie in court. Yep, they got that right, sadly. I am reading this with all due sarcasm that women who are victims should not be afraid to report in court just because one person lied, though somebody lying in court hurts all victims because it allows some jurors who are inclined to not believe victims to say, see, but this one lied. That is a problem. So maybe holding Amber Heard's feet to responsibility is what's needed. Appendix is missing and Chu called them out per Virginia appeal rules. Well, we'll get to Chu's sassy sass in a minute. Introduction. The amici are gravely concerned that the verdict for Johnny Depp and Depp v. Heard against his former wife, Amber Heard, casts an enormous shadow over the First Amendment law, intimate partner abuse victims, incentives to report abuse by their attackers, and the ability of Americans to speak out about injustices. That's a lot. Peachy Smill in the chat said they had an appendectomy. It's very clever. If not reversed, this verdict will have a profound effects on the jurisprudence of the Virginia. Wait, are we meeting Virginia? Who's Virginia? If not reversed, I was teasing. If not reversed, this verdict will have profound effects on the jurisprudence of the Virginia and further effects on the ability of women nationwide to stand up to their abusers. Can you tell me how? The verdict will have a chilling effect on a wide range of commentators. Amber Heard's fans have tried to have a chilling effect on a wide range of commentators. I don't think commentators are the problem here. Amber Heard's not a commentator. Amber Heard is the speaker of the things that happened. Specifically, the verdict has already and will continue to deter women who have been abused by their partners. Are any of them speaking up here? I hope that no one is deterred by this. Because if you are telling the truth, there are plenty of resources available to you and someone can't sue you for defamation. Well, they can sue you. It's America. People can sue you for fucking anything. But I truly believe the truth will out, even when it's difficult. Specifically, the verdict has already and will continue to deter women who have been abused by their partners from reporting such abuse, whether it be, among others, mental, psychological, verbal, physical, emotional, and sexual. Not only was this a highly publicized trial, it's because they're celebrities, but it became a social media sensation, possibly in a manner that was not wholly organic. What now? Pot. Stop calling the kettle black. Possibly, first of all, possibly in a manner that was not wholly organic. What are you implying? It is a common tactic for an abuser to sue their victims for defamation, re-traumatizing them and impoverishing them through the legal system. Amber Heard wasn't impoverished. This is about this case. Charlie said, shouldn't it say victims and not women? That's not their perspective on this. It is a common tactic for an abuser to sue their victims for defamation, re-traumatizing them and impoverishing them through the legal system. That is part of why there are SLAPP laws. It is a consideration. This problem only worsened during the Me Too movement. And this tactic has accelerated due to the verdict in this case. Per this person's opinion? Is this an opinion piece? Lawyers have noticed a substantial increase in defamation cases involving domestic violence and sexual abuse in recent years. Between 2014 and 2020, there were at least 100 defamation cases filed by those accused of sexual misconduct, most of which were filed after the Me Too movement began. I think it shows how I don't think this is a necessarily neat correlation, because I think it also shows how damaging an allegation can be before it's gone through the court of law. Somebody asked, who filed this? We don't know. Do we know who filed this? No. The amici did not include an appendix with who the fuck we are, which is why I think this will just get yeeted. I don't think the court can consider this at all. You have to prove who you are, just like the Onion did in their amicus. This is who we are, and this is why we're interested. Identified in Appendix A. There's no appendix. We don't know who filed this. Someone who has an opinion. Because these are opinions. Equality Now, a rights organization, similarly reports seeing a worldwide increase in perpetrators filing a worldwide increase. Does everyone have the same defamation law we do? Footnote 2. While the trial of this case was incredibly invasive into Ms. Heard's privacy, I have thoughts. With such irrelevant matters such as my brain stopped. With such irrelevant matters, with such irrelevant matters such as testimony about an alleged incident in the Seattle airport in her past. She was arrested for domestic violence in a domestic violence case. I don't know how that's irrelevant. And the court, I think, erred in Amber Heard's favor by not letting the fact of the arrest come in. The facts were allowed to come in. If Amber Heard hadn't testified, they probably wouldn't have come in. But that's not irrelevant. This sentence is written so fucking badly. While the trial of this case was incredibly invasive into Miss Heard's privacy with such irrelevant matter such as testimony about an alleged incident in the Seattle airport in her past for most victims of abuse, it is the invasiveness of the pretrial discovery, including depositions, that is the most harmful. Ugh. This is opinion, and discovery is necessary in a civil case. Discovery is necessary in a criminal case. Discovery is going to happen. Can discovery feel invasive? Yes, but discovery has to happen. This case was incredibly invasive into Ms. Heard's privacy. Then she should not have chosen to make it a matter of public discourse. If she had not written the op-ed, this would have never come up. Not to mention, there seemed to have been a protective order in this case wherein the testimony regarding the sexual assault would not have been public. It would have been testimony just to the jury. But Amber Heard's team violated that protective order in their opening statement because Elaine brought it up in graphic detail in opening. So it wouldn't have been as invasive as they hadn't tried to use it, but they used it in opening. Therefore, it became invasive. The drafting on this. Tell me who you are and why you have an interest in this. The argument of Mr. Depp's counsel to the jury relied on many assertions that are nowhere within the four corners of the editorial at issue or reasonably derived therefrom. The defamation by implication doctrine has been so unduly expanded in this case that it will lead to numerous meritless attacks on editorials and other publications that claimants will assert contain implied references, regardless of how dubious the implication. They're not suing the publication. If they're suing the publication, you can make that argument. You know what happened when Depp sued the publication? He lost. Because they found that the publication could reasonably rely on Amber Heard. You know what the jury in the U.S. say? The jury in the U.S. said, you can't reasonably rely on Amber Heard. We don't believe her. Publications should feel safer after this verdict, because even after Amber Heard was found by the jury to have defamed Johnny Depp, the publication is not going to be attacked because the publication might have had reason to believe her based on her side of the story only. Publications are much more protected than this is implying. In order to find Ms. Heard liable for defamation by implication, this was a jury trial, not a court trial, this was a jury trial. A court must make numerous leaps of logic that are not justified by the actual words of Ms. Heard's op-ed or the reasonable implications therefrom. The jury disagrees. Requiring victims to defend against such lawsuits without proper First Amendment protections will cause speakers to either choose not to speak or to incur significant costs, usually against litigants who have far superior assets. Well, I feel like that's a bit sexist. The publication at issue. On December 18th, the Washington Post published an editorial written by Appellant Heard with the assistance of the ACLU and her own private counsel, and the three of them together could not avoid this lawsuit. Ms. Heard has been invited to become an ambassador by the ACLU and to work with the ACLU on an op-ed to bring attention to gender justice issues. Footnote 4. The ACLU has explained, quote, the op-ed also pushed for legislative and regulatory reforms that the ACLU has long supported as part of our women's rights and gender justice work. The ACLU also wanted to spice it up by referencing Johnny Depp a bit more. Tell me more about that. They wanted to use it to galvanize support for changes in the treatment of women who came forward to speak out against abuse. Amber Heard advocated that readers help elect politicians who would assist in fighting abuse and pave the way for better investigations by providing proper follow-through of complaints and assurances of no retaliation. I don't know how you get those assurances, but if you feel that your politicians are failing you, vote. And let's talk about the funding to get rape kits tried. Let's start there. Let's start with not enough funding to test the kits that people have. Can we start there? How much money are you spending on this Amicus? In the op-ed, Ms. Heard explained that because she spoke out about domestic abuse, she had become ostracized and lost employment as an actress. What roles did she have before this op-ed? Because she landed Aquaman. Well, they announced Aquaman when this went live, and she did not lose her role. Eames said, and bias training for officers. Officers in most jurisdictions do bias training. I don't think they do enough domestic violence training, though. but law enforcement agencies are not sufficiently funded to deal with that, and they tend to be leaning into just being as responsive as possible to the most serious violent crimes. Brenda Davis said, yes, the rape kits sit for several years, never tested. So, there is room, lots of room for improvement. Is this case the case that is crumbling it all down? No, it's not. As the Washington Post later wrote, the op-ed urged readers to support women who came forward with allegations of abuse by taking them seriously and electing politicians who will fight for changes to laws and rules and social norms. I don't know if it's the role of politicians to fight for social norms. I think society has to do that. But I think people who come forward, not just women who come forward, humans who come forward should be taken seriously. And then it should be vetted in a court of law when we have serious implications. Yes, sometimes those have to go to court. But that's not all that was said in the op-ed. They used Johnny Depp and the allegations about Johnny Depp to spice up this op-ed to get it more traction. That is the problem. Rob donated an appendix to your inbox. Okay, Rob, thank you. I will find it. I'm gonna read what Chu had to say about it first. The op-ed never mentioned Heard's former husband by name or by reference. False. Such as former spouse. No, she mentioned the timeline. Nor ever stated that Heard had been subject to any particular type of abuse. Hold on. Where's the abuse takes many forms statement? I believe they listed sexual abuse in the abuse whether it be, among others, mental, psychological, verbal, physical, emotional, or sexual abuse. I spoke up against sexual violence and faced our culture's wrath. Okay. Okay. So tell me again how she didn't state she had been subjected to a particular kind of abuse. Because also, she said, 2 years ago, I became a public figure representing domestic abuse. So that's two kinds of abuse. No? Did I read that properly? Chat, am I reading that correctly? Instead, other than the contested passages, the op-ed merely explained that she had been exposed to abuse at a young age. That's downplaying it. And said, like many women, she had been harassed and sexually assaulted by the time she was of college age. And I think this is where Rottenborn wanted to go with this trial. You know what she didn't testify to at trial at all? Being exposed to abuse from a young age, really, and being harassed and sexually assaulted by the time she was of college age. Those two things never came up in the trial. And she never said, these are the experiences I talked about. What she said was, that's why I wrote it about him. I think she could have leaned into this. I think she absolutely could have leaned into this. The problem of assault on college campuses is a huge issue. I think she could have leaned into it, but she didn't. That's not what she testified to. That was not her testimony. Her testimony was over and over and over and over about Johnny Depp and saying, that's why I wrote it about him. That was her testimony. The introduction of the op-ed listed Heard as an actress and ambassador on women's rights. The op-ed contained 2 sentences that Mr. Depp claimed were defamatory and the jury found were. They didn't say that, I did. Neither mentioned Depp nor specifies a type of abuse. Actually, the headline the headline needs to be in here because she was found liable on 3 counts. And when you talk about institutions protecting men accused of abuse, I didn't think she was talking about college institutions. The rest of the op-ed addressed the repercussions experienced by women who speak up regarding abuse, which needs to continue to be addressed. The op-ed took a broad view, referring to the Me Too movement and the history of Hollywood, which also implies Depp, because Hollywood. Other negative publications about Depp. This is going to go into what they went into in the trial. Depp's unsuccessful British lawsuit is irrelevant here, except that it directly contradicts their argument that publications should be scared. Publications were protected. Let's go look at Ben Chu's response to this, because so far we haven't even gotten to the law or the argument, and I literally can't. And I know this has been covered very broadly on the internet, and you guys have seen it. So we're going to just go to Ben Chu's response to it, and then if we need to refer back to this, we will refer back to it, because I want to see Chu's response, and then I need to find. Rob sent me the appendix. Why wasn't it attached? Rob sent me the appendix and I need to go find it. Let's see. I am missing things that are happening. Give me a second. All right, why are my texts blowing up? All right. Because I've been streaming forever. Oh, because it's like almost 3 hours in. All right, that's what we're all going to be. We're all going to be good. Let's see. Rob, I'm looking at Signal. You got to scroll to the end. Okay, thanks, Rob. I will. Let me just. Oh, I can't airdrop this while I'm streaming. I'll take care of it and I'll grab it. Thank you, Rob. Let me grab this and put it where I can grab it on my computer. So give me 1 second. All right. I'll be able to grab that in a minute. Let's take a look at chewing this up. She called her father a salt of the earth guy. She did. I was surprised because I was really thinking that she was going to lean in from Rottenborn's opening. I really thought, and then Elaine kind of killed it, but I really thought she was going to lean into, this is the abuse I suffered at a young age. This was my experience leading up into college. This is why I wrote this op-ed. And Depp was an alcoholic, a drug addict. He yelled at me. He pushed me. He kept me from visiting my friends. He was late to my party and caused a scene. And these all culminated with me going to seek a protective order because I wanted to change my locks. And then my face was on the cover of everything. And then I was representing domestic abuse. And that's not what I wanted. But I've had all these experiences and I felt like I needed to use my voice. And that's why I wrote this op-ed. But that is not the way the testimony went. Because that is not Amber's story. Amber's story is, I was subjected to the most horrific abuse you've ever heard. And I'm going to tell you about it. All right. So thank you, Real Laura B, for sending this so I could read it, which hastened it instead of me just emailing the court or calling the court and being like, yo, can I get that? Which I will do for the next one and share it with the class. Amber Laura Heard, John C. Depp, appellee's omnibus opposition to Amici to the amicus motions for leave to file briefs, amicus curiae. Here's the thing. The amicus are asking, hey, can you consider this? The court can say, no, fuck off. Appellant Depp, through his undersigned counsel, respectfully submits this omnibus opposition to the motion for leave to file brief of amicus curiae sanctuary for families, the Virginia National Organization for Women. Here it is. To avoid burdening the court with the duplicative briefing, and because the issues overlap, Mr. Depp addresses both motions in this opposition. There are 2 amicus. We've only looked at 1. Let's see who said this. Sanctuary for Families, Virginia National Organization for Women, the DC Coalition Against Domestic Violence, Equality Now, Esperanza United, Feminist Majority Foundation, Battered Women's Justice Project, the Women's Equal Justice Project, National Crime Victim Law Institution, Coalition Against Trafficking in Women, and Professor Catherine A. McKinnon et al. In support of defendant appellant, filed for the amici by Simpson Thatcher Bartlett, and the motion for leave to file an amicus brief filed for the amici by Fletcher Harold. Is that the motion we were just looking at? Hold on, let me go see if the Fletcher Harold motion was the one we were just looking at. I now need to know which one is the one we were just looking at. Because I want to know what we're talking about. I'm pulling up a separate tab so I can just go back and forth. Let's see. That's not it. Which is the one with the lawyers from Redondo Beach? The second one. So the one where Ben Chu is not listing the names is the Fletcher Harold Hildreth one, because this one is the one that did not have the appendix. Introduction. This is a kitchen sink appeal. I mean, facts. Facts. With appellant purporting to assert no fewer than 16 assignment of errors, it was definitely not tailored. Appellant Heard, who is represented by two large and well-regarded law firms, is seeking to relitigate virtually every major ruling made by two distinguished and highly represented chief judges of the Fairfax County Circuit Court. Honorable Bruce White, Honorable Penny Oscarade. Over the course of a 3-year litigation and 6-week trial. In addition to the oversized brief, I like big briefs and I cannot lie. You other brothers can't deny. When a girl walks in with an itty bitty waist and a big brief in your face, I like big briefs. It is definitely a kitchen sink appeal. It was not narrowly tailored. I've made that complaint. I feel you, Ben Chu. I've made that complaint. In the addition of an oversized brief of 55 pages that Ms. Heard has filed in support of her appeal, the Amica, seek to present a collective of 93 additional pages of argument in support of Ms. Heard's positions. We're not done yelling into the air about how angry we are with this verdict. We're not done. I left out the D. Rob, I did leave out the D. It's Bruce D. White. We got to have the D. I'm just bitter about my D being left out earlier. Bruce D. White, Emily D. Baker, and Robert D. Morton. Most of the chat should know who Robert D. Morton is. Some of you won't. There's some that won't. I'm just saying. Oh, Ben Chu is just like, let me get to the point here. What? If the motions were granted, Mr. Depp would be required to respond to a total of 148 pages of bullshit. I'm sorry, that's not what it says. 148 pages with his own brief, which presently is set at 55 pages. Though there are doubtless cases in which briefing by amici might assist the court in resolving the issues before it, this is not one of them. Yeah, this is not this case. They keep trying to make this case mean more than it does, and I just disagree. This is a case between two celebrities whose relationship seemed awful, whose marriage dissolved horribly, and who ended up in court over defamation. This is an anomaly. This is not a case that is going to change the way most people live their lives. Robert Morton requires the D to get through all those stacks. The D stands for daddy. Yes, that's what the D stands for. Mr. Depp respectfully submits that the filing of such extensive additional briefing is neither necessary nor appropriate and should not be allowed. Yeet, Your Honor, yeet. As a threshold matter, the court should deny their motions because the amici failed to comply with the applicable rules by inter alia, neglecting to properly assign error, which violation constitutes sufficient grounds for denial. Your Honor, you could yeet this. You could yeet this immediately. The chat, Rob. The chat. Moreover, Ms. Heard is very completely represented thoroughly. She has stacks of lawyers and is not in need of assistance or additional briefing to support her position, nor should Mr. Depp be burdened with having to respond to such voluminous nonsense. I'm sorry, voluminous additional briefing. Because they're making policy arguments. They're making the arguments they want the public to hear. It feels like, at least from what we've reviewed, that the amicus brief is public. Fuck you. You're wrong. You didn't believe her and you're wrong. And we want you to know that you're wrong. And we're going to keep telling you that you're wrong. And there's experts that say that you're wrong. Listen, public, listen to us. I don't care that you watch the trial. You were fooled. You are wrong. And you need to listen to us. That's what the amicus feel like they're doing. But that is not the purpose of an amicus brief. So let us continue. Oh, that makes sense why there is the precipice, the additional, like, we don't need assignment of errors that was filed after the fact. Finally, the amicus argument add nothing to the legal analysis provided by appellant Heard's counsel and appear focused instead on arguing with the jury's clear findings in favor of Mr. Depp. I should have kept reading. Yeah, the amicus are all PR. The amicus are all PR. Or my opinion, my perspective. Clear findings in favor of Mr. Depp on the underlying factual issues. The amicus proceeds from the essential premise that Ms. Heard is a representative of domestic abuse victims, a premise that was emphatically and soundly rejected by the jury, who paid careful attention to the evidence presented during the 6-week trial. It's a very good argument. She is not representative of a class that is otherwise unheard. Both amicus briefs cherry pick evidence that they believe should have swayed the jury to a different finding, but offer the court no insight on the legal issues actually at issue in Ms. Heard's appeal. Allowing this additional briefing would merely serve to complicate what is already a sprawling, misplaced appeal. Ooh. Your Honor, they've already thrown all the spaghetti against the wall. Stop it. Accordingly, Mr. Depp most respectfully requests that the court deny the motions. Footnote 2. It bears noting that the trial court rejected a motion to file an amicus brief at the pleading stage of this case for many of the same reasons that the motions should be denied here, when then Chief Justice White noted on the record that, quote, Ms. Heard's counsel in the case are highly experienced and would, quote, present the law quite adequately in the court, while rejecting the suggestion that the trial court, quote, in ruling on the specific case should take the amicus policy goals into effort, as opposed to really, in this case, on what the law already is in the Commonwealth and the evidence and the facts that I hear. That's an awkward split. But the judge in Virginia said, yeah, we don't need your help. Thanks, but we don't need your help. Let's get back to where we were. Oh, it adds no legal analysis. And they lead from a false premise. Notice that what we don't have is a description of what a false premise is. Argument: the court should deny leave because the amicus failed to comply with the applicable rules. The amici, the amica, failed to comply with the applicable rules, to wit, a brief amicus curiae must comply with the rules applicable to the brief of the party supported. Because the amici are seeking to support Ms. Heard's opening brief on her appeal, they are required to comply with all of the requirements set forth in 5A:20, including the requirement under Rule 5A:20C that a brief must contain a separate heading for assignments of error with a list of the specific errors claimed. They definitely didn't do that. And, quote, an exact reference to the page of the record where the error has been preserved. A failure to assign error or insufficiencies in the assignments of error are both a basis to dismiss an appeal, as is the failure to adequately support an assignment of error with citations to the relevant pages of the record. So they're saying you have to tell us, sorry, I forgot to make this big. You have to tell us what you're appealing. What is the problem? What's the problem, dog? What did the judge do that we can undo? Not just the jury verdict is damaging because we don't like it. That's not an assignment of error. Here, neither the brief offered by the Simpson amici nor the brief offered by the Fletcher amici complies with these express requirements. The Fletcher amici brief does not contain a section for assignments of error at all, while the Simpson amici include a separate section for assignments of error but fail to support it with any citations to the record, probably because they didn't have the records. In addition to their failure to provide any supporting citation, the Simpson amici also violated the rules by using a size 12 font rather than the required size 14, meaning their brief is actually even longer than it appears on their face. Don't fuck around with the appellate court using the wrong font size, man. The wrong font size will annoy me more than 40-lined paper. No, it won't. 40-lined paper is worse. This is almost as bad. Based on their clear formatting errors, the court should deny their motions. You guys are like, does the court really care? Does the court really care about font size? Yes. And as a research attorney, I would be like, Your Honor, these procedural things were not meant. Can we eat it? Can we eat it? Can we eat it? Can we eat it? But the font trick is not going to work for them. The court might be really annoyed by that. I would be annoyed by that. As a research attorney, I would have been annoyed by that. Well, I always was annoyed by that. I don't have to speak in the abstract. I was. The court should deny leave to file the brief because appellant is well represented. Her insurance companies have taken care of it, Your Honor. And responding to the amicus would unnecessarily burden Mr. Depp. Subject to exceptions not pertinent here, a brief amicus curiae is permitted only on motion and by consent of the court. The rules therefore reflect that such briefing is generally considered unnecessary, nor would it be necessary or helpful in this case. It's undisputed that Ms. Heard is well represented in this action by two major law firms, Ballard Spahr and Woods Rogers, which also acted as Ms. Heard's co-lead counsel at trial, referring to Woods Rogers and Rottenborn. On behalf of Ms. Heard, Woods Rogers and Ballard Spahr have already filed an oversized brief at 55 pages that seeks to put at issue 16 separate assignment of errors. 16. She certainly does not need an additional 93 pages of additional support briefing from outside amici. As noted above, in light of the Simpson amici's use of a smaller font size, the actual pages of extra briefing are closer to 100 to adequately present her arguments to the court. Your Honor, she's trying to en route the page limits. She just wants to say more shit. Though I think some of it is PR. It's so funny how they're talking about, Heard's team talks about whether or not these numbers were, or the social media reach was improperly inflated. But the amount of flinging things at the public that I have seen has mostly come from the pro-Heard side. Maybe I've missed it. But when I look at social, what I'm seeing is, and until recently it's slowed down, but pro-Heard bad public headlines. Heard good, public dumb. Heard good, public bad. Heard's a victim. The public was fooled. The public is misogynistic. The public doesn't understand that Depp is really the abuser. The public doesn't understand that this is how abusers work, and they flip the script and make the victim be the abuser. They change the position, and the public didn't understand. The public didn't understand. That's what I've seen. I've not seen a lot of defense of Heard, and what I've seen is when he was on the MTV Video Awards that people were attacking him, and people were attacking MTV. When he was in Rihanna's fashion show, people were attacking him and attacking her because he was there. That's what I'm seeing. So, this feels like another attempt to do that. Moreover, Heard's counsel appear to be acting in coordination with counsel for the amici which strongly indicates an attempt by appellant Heard to circumvent the page limits imposed on both parties. For example, in the proposed amicus brief offered by the Simpson Amici, which is filed and served the same day as Heard's opening brief, Ms. Heard's entire statement of facts is simply incorporated by reference. What? Well, how would they know that if they didn't read it? In an opening acknowledgement that the amici had previously received Heard's brief and were acting in coordination with their counsel. Nighthound, wasn't Rihanna herself a victim of DV? Yes. Yes, and I don't think wanted to be a public face representing DV, and it got out because it was leaked. She was not protected in that well. Her privacy, she did not put that at issue. Her privacy was, well, that's a whole separate conversation. But yes, she was. Mr. Depp, who has received leave to file a brief of only 55 pages, would be unnecessarily and unfairly burdened by, if the amicus briefs were allowed, Mr. Depp must already respond to Heard's highly unusual, ridiculous, 16 separate assignments of error in a single brief. Oh, I felt bad for Rihanna too. I felt really bad for Rihanna, and people were saying, you stand with domestic abusers. I'm like, y'all, let's not. People came after her pretty aggressively. It says a lot that she knew, or at least her people would have suspected that was going to happen and said, I don't care. This is what I'm doing. It speaks a lot to her character in a very, very good way. Further, Mr. Depp must also address the 3 additional assignments of error he identified for the court's consideration in the event of a remand. If the amicus were allowed, Mr. Depp would also be forced to address their 93 pages of argument, totaling 148, all in the same responsive brief. The burden on Mr. Depp of doing so would be substantial and unjustified and expensive. The court should deny leave because the arguments of the amici are irrelevant and inappropriate. Ooh. Mr. Depp will not address the substance of the amici's argument in detail in this opposition, other than to point out that the arguments in their briefs are for the most irrelevant to the legal issues on this appeal and consist largely of disagreements with the jury's factual findings. I mean, from what we've looked at, or complaints about the impact of the jury's findings on society in general. Yes, which is not the point of an amicus brief. This will impact society. Reporters and commentators won't be protected by the First Amendment. Bro, what? The Amica cherry-picked and misstate evidence that they maintain supports their personal factual conclusions. We didn't even get very far in, and we saw a lot of that. To argue that the jury got the factual issues wrong, which is not the point of appeal, while ignoring the substantial evidence, including testimony of credible, disinterested witnesses, that was presented to the trier of fact of Miss Heard's abusive conduct, admissions, and conspicuous lack of credibility. The Amica also expend many pages arguing that the jury's verdict is somehow harmful to abuse victims in general. Such statements are wholly inappropriate on appeal. Yeah. The court should not substitute its own judgment, much less the judgment of the Amica, for that of the jury. That's not the point of an appeal. The point of the appeal is not the jury's dumb and misogynistic. That's not the point of the appeal. The point of the appeal is to argue that the law is wrong, or argue that if the court changes this law, it's going to have this impact. If you review this law, because the appeal is about the law, not about the facts. The judge got it wrong. This jury instruction misstates the law. Yeet the jury instruction. Here's our experience with that jury instruction and how it impacts us as amicus. Likewise, the amicus focus on some perceived social harm that will result to abuse victims generally from the verdict is both factually misguided, because the jury clearly and emphatically concluded that Mr. Depp is not an abuser, and inappropriate argument, because the jury was tasked with making a factual determination with respect to only the parties in this action, not with sending a message to society writ large, which is the point. This case is about them. I know they want to make fetch happen and make it bigger because it was so publicized. But there's times that this feels to me like, the ACLU wanted, this was my takeaway from the ACLU testimony. The ACLU wanted to use Depp to bolster their perspective of these issues, to champion politicians that they agree with, and they wanted to use Amber Heard's position vis-a-vis Depp's notoriety and the fact that the media will pick it up to bolster those positions. It feels like Amber Heard is still being used in that way, and Mr. Depp is still being used in that way by other entities that want to take what happened between these two individuals and use them to bolster their positions. And it doesn't matter if we agree or disagree with the positions. Should we have politicians who believe victims of abuse? Yes. Should we have politicians that protect people? Yes. Should we have politicians that listen to people? Yes. But no matter how emphatically you agree with that, this case is no longer a hockey puck for social change. That's not what it's for. And they are trying to make it for that. Write the articles. That's what the media is for. Write the articles. Have the opinions. Give the social commentary. Write the op-eds. Fine. But it's not for the Court of Appeals to do. Hutchins versus Commonwealth. They say closing argument asking a jury to send a message to society is, in general, was improper. Both parties kind of argued this in their closing, didn't they? Both parties kind of argued this. Rottenborn argued this more than Ben Chu did. Ben Chu was more, tell the world, that Johnny Depp is not an abuser. Give this man his life back. And the tell the world kind of came more from Amber Heard's own words in that audio. Tell the world, Johnny, no one will believe you. Those words. Who's going to believe you? Something I've seen abusers say time and time again in my experience. Who's going to believe you? Ben Rottenborn said, if you fine for Johnny Depp, you are telling people everywhere that there's never enough evidence, that there's nothing you can do, that you will never be believed. Which is why it was objected to. Closing argument asking a jury to send a message to society in general was improper because of its tendency to inflame a juror's prejudices and to, quote, divert the juror's attention from the evidence produced at trial and focus it upon extraneous and inadmissible matters. Isn't that what Rottenborn was doing in part of his closing? Just saying. Was that before he was interrupted by an Amber Alert or after? I don't remember. In this context, it would be unfair to force Mr. Depp to use some of his limited pages in responding to these extraneous arguments. Moreover, a back and forth between Mr. Depp and the Amicus on these non-issues would be a distraction and add nothing useful to the court. Nothing at all. Conclusion, based on the aforesaid, the court should yeet. Yeet, yeet. Yeet. That's how many people it had to respond to. Yeet, 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 yeet. All right, let me go see if we have the appendix. I sent it to myself. Rob sent it to me and I sent it to myself. Let's go take a look. Where is it? I sent it to myself badly, apparently. Hold on. We are professionals here, people. WAP. I can't airdrop because I will screw up my streaming. Let's do this one more time. Eat. Why didn't it send? Why won't it send? Send. Eat. Yeet. It's here. It's just not. I'm going to get to questions in a second if this refuses to send again. Why won't it send? It just refuses to send. That's annoying. All right. Well, Rob, I've seen it. You have sent it. And let me see. I'm going to look at it on my phone real quick. I should have my iPad here when I stream, and then I could have pulled it up. We're going to scroll to the end. And let's see. There is a very long Appendix A. It might just not have been on the copy that I have. It might have been added later. I don't know. But there is a very long Appendix A with, is this the same brief I was looking at? Because this lists the same group that are in the other brief. This is the second amicus, Rob. So thank you. The first amicus doesn't have the appendix. This is the second one. There are two. So thank you. That's the one that he listed. I still don't think there's an appendix. Here's why I don't think there's an appendix of who filed it. Because Ben Shu doesn't list who the amicus are. He lists it with regard to the Simpson brief. He lists all of the individuals that are amicus in the Simpson brief. But the Fletcher brief, he doesn't list who they are because there's no appendix. So that's the group that Ben Shu put in his response. Yeah, there's two amici briefs. We need to get to questions. We need to get to questions. I also have a question. I need to Google real quick. There's something I've been wanting to look at, but we will get to questions as we get to it, and then we will wrap up. Because we're talking about Me Too. Is this Harvey Weinstein jury still out? Yep. Jury deliberations enter their 6th day. That's a long time for the jury to be deliberating. That's a long time for this jury to be deliberating. Yeah, that's a long time for this jury to be deliberating. I'm curious if they've been sending out notes. I'm gonna have to look at it. We'll address it on Tuesday, but that's a long time. So I don't think we're gonna see a Weinstein verdict today. That's interesting. 6 days is a real long time. All right, let's go to questions. I've got questions. You've got questions. We've got questions. We're only 3 hours in. I mean, we do this now, apparently. Miguelina, if we still have a poll about whether I need to be a gaming streamer, can we take that down? Somebody in the chat's getting tacos. I want tacos. Why are they deliberating so long? How can they be deliberating so long in the Weinstein case? Because they can't agree yet. That's why. That would be the only thing, is that they can't agree yet. But it's time to FAQ around and find out. We've got questions. We've got super chats to get to. I can't believe it's already 4 o'clock. It is dark outside. Look, y'all. It is not daylight outside. It is 4:21 Central, and it is not daylight. "57% of you were like yes to gaming, and 42% of you are like, girl, who do you think you are?" We will take it under advisement for gaming. Maybe we will occasionally do a gaming stream on this channel and then just not leave it up. Maybe. So let's see. JL Cupcakes said it's 4:21 here and it's still daylight. It is definitely not light outside. Kelly Being, hopefully they're not pouring over genitalia photos. I really, really hope for that Weinstein verdict that they're not going through photos again. I hope not. We made it through the amicus, sort of, and we made it through the response of this shouldn't be allowed. We'll see what the court decides to do. The court does not have to allow the amicus. I wonder how much of it was filed for PR, just to get the sentiments out there, because it just seems from the one that we looked at, and we can look at the other one, but I don't know if we need to, that they are proffering the same arguments that we've been seeing in media reports too. Experts say the jury got it wrong. Well, the jury got it wrong is not the point of the appeal. The point of the appeal is not the jury got it wrong. It's the court got it wrong on this ruling, or the court got it wrong on that ruling. That's the point. What did Amber want? A body cavity search too. Well, her attorney seemed to argue that they didn't thoroughly search, but that was the jury could have decided that that was the part that was defamatory. The officers didn't ask for her therapy notes. Maybe that's what she was upset about. They sure didn't. Watching I-5 said, if you don't need any context for a statement, how would that work with a comment in a video or a tweet in a thread? It seems like a slippery slope. I think things being taken out of context are tough, because when the court is like, the meaning is the meaning, it's the meaning, the context helps with what that meaning really is, though. But what they're saying is that Waldman's statements aren't changed by the way the article's written. So if Waldman's statement wasn't the complete statement, you would have to go with completeness. The whole statement is this. You can't just go with like the middle part. But they're arguing that everything else in the article isn't relevant. And that's how they're trying to get there. And that's what the court decided. They left in context of Amber Heard's entire op-ed, which actually I think could have benefited her to the jury. If the jury had believed her, it would have benefited her, because they could have said, look, she's talking about a lot of things in this op-ed. They didn't believe her, so it did not benefit her. So we will see. But yes, context matters. But the court also has to go with, look, we're not supposed to be doing hurdles. We're supposed to be looking at the words, what they say, and then defamation by implication has, rules inside of rules. Isaac also said he saw wine spilled in the hallway after JD and the cops had left. He came home 1 hour before and he didn't see it then, just timing issues, which is fair. So it goes again to JD wasn't the one who spilled the wine, which is what Amber Heard said. Amber Heard and her friends spilled the wine, but was it after all the officers left? And if it's after all the officers left, then the jury could be parsing the timing on that statement. They very well could be. Owned by 3 bullies. Erica, have you heard that Congress has asked Ticketmaster for a briefing no later than December 15th regarding Taylor Swift? I would love to see that. Eden said, just found your live yesterday and wanted to say, I love and appreciate what you're doing, making these things accessible. That's my goal. Thank you, Eden, for seeing me. My goal is to make the law accessible to all and sometimes be a little spicy while we do it. Sometimes have a little fun. You're welcome. CMB, I saw this and I started. I'm so sorry that you're going through it with your mom. I hope that things heal smoothly, that your mom recovers smoothly, and that the stress of what you were going through passes quickly with your mom's healing. That is a very hard thing to go through. So a big hug from us. Emily said she doesn't even go hear facts. Is Appendix A attached to the amicus brief number 1, perhaps? No, they have a different set of amici. It should be totally different amici. 4C process. Hit that like, y'all. Thank you so much. Next week, we're going to be getting away from this and back into Britney Spears coverage, back into all of the other cases that we need to catch up with. It's a lot. And then I will be going on vacation. So if you guys want to keep up with me, the member spaces are probably where I will be most present while I'm away, sharing some of that stuff. But I will be gone, just so you know, I will be gone. I will be out. Let's see. When is our last stream for 2022? It's coming up. Which is stressing me out, by the way. I have so much to do before then, but our last stream is going to be December 20th, and then I will be gone till the new year. So we've got next week, we've got a members only live stream next week, on Wednesday. So we have next week, and then, so 3 more streams this year. 3 more streams this year is what I'm anticipating. There will be podcast episodes coming out on the 21st and the 28th while I am gone, but we only have streams till the 20th, and then there will not be any streams until the new year. Until the new year. I'm sorry, y'all. Who approved this? My family, whose vacation I brutally canceled in the middle of the Depp Heard trial. So that just so you know, there will be a members only live stream next week. So if you want to do that, you can join as a member here on the channel or at lawnerdsunite.com. And then that will add a fourth stream before I leave. And then we will have members only content and podcasts. So that's what we will have as we go. All right, let us continue. What else? Brittany said, my birthday is the 21st. Happy early birthday. Question, Murdoch case starts next week. It does not. The Murdoch case starts in January. So the trial starts in January anyway, unless they bumped it forward, which will be a big fucking problem. But it's supposed to start in January. Question, are they allowed to submit the corrections they did to fix the issues Ben Shu pointed out in response? No. No. They submitted a precipice to try to fix it, and the precipice was like, we don't need assignment of errors. I don't know if the no assignment of errors is the strongest. I think the strongest argument is this doesn't even address the law. Like, this isn't even addressing the law. Oh, I will be on your TVs while I'm gone as well. So once I have the date for that, I think that airs right after Christmas. So I will be on the TVs while I'm gone. So I'll keep you posted on that. There will be a number of behind the scenes recording because I have to pre-record. So for the members, there will be behind the scenes podcast recordings as well. So yes, there will be recording. There will be the members only live stream, but there also will be behind the scenes podcast recordings because I have a bunch of pre-recording to do. Teresa said, being a survivor of DV, I'm offended and I feel disrespected by all the lies and false accusations that were made. Victims typically have documents, pictures, and reports to back up their stories. Yeah. So it is, first of all, IPV is so personal to what's, okay, Fred, come on now. IPV is so specific, case by case, individual by individual. But you generally have things that indicate what's going on, be they text messages, be they injuries, be they, documents, records, things like that. You generally have something. And we in this case had that too. The jury didn't agree with Amber Heard. There were recordings of them together. There were recordings of them arguing and fighting. There were recordings of Johnny Depp. There were recordings in this case. I think the audio recordings were probably the most telling to the jury. That's just my opinion. But yes, Rottenborn's argument that there will never be enough evidence was not well taken for me. Stephanie said, Rottenborn, so you're not a California citizen. An insurance company isn't going to pay me since it was intentional. Okay, really need to write your brief now. Ready to write your brief now. Side Emily, thoroughly enjoying the new mic and your ability to quickly bring the mic closer for emphasis. Me too, Irish Aiden. I am not going to stop playing with my mic boom. I'm obsessed and I love it. And we can very quickly turn this stream into an ASMR stream. I am obsessed. I won't stop. Will you be covering the Murdaugh murders? Yes. Yes, I will. Motion hearings happening now. Are they still going? I saw that they were going. I think I might cover that on Tuesday. Are they still going? Let's see if they're still going. Let's see. Oh, I'm coming up on the top of the watch page for me. Great. Oh, is there more Twitter? It looks like there's more Twitter stuff going on. It looks like they are. I don't see that they are still live on those, but I think I might cover those on Tuesday. I'm going to wait and see what happened and cover that on Tuesday, or see if I can clip it down and cover it on Tuesday. But I'll have to take a look. Let me go over to disfavored channel. And see. Those are all upcoming. That's not what I'm looking for. Let's see if their old live stream is still up. They must have. Where did it go? Law and Crime, you just streamed it. Did they take it down already? Maybe. I said something and then Law and Crime's like, no, goodbye. We're not doing that. I don't see. They streamed it and now the stream is gone. So I will have to go look for it. But it looks like it's done. They are not still live with that right now. So I can go, let's see if Court TV did it. Now I'm just answering questions while we're doing it. Court TV had the hearing. It was an hour and 45 minutes long. Maybe we just cover that on Tuesday from Court TV. And then we can zoom through whatever breaks they take, because that's up. They just streamed it. That's up on Court TV's site. So maybe we'll do that. So maybe we'll do that. I think we should. Love your new mic and change of voices. Me too. I did look under the lives over on Law & Crime. I did. I could not see it. Can a member replay the members only? Yes. Murdaugh's still going now? No. Isn't Amber Heard suing Elon for child support? I have no idea. Julia said they split up the videos and lives into different tabs on YouTube. I saw, but I went over to, they just started doing that not that long ago, which caused some confusion on this channel as well. But when I went over to, oh, this auto plays. When I went over to their channel, oh, I'm not on screen share. I might be missing it. I mean, it's possible. We don't need to give them more time. I mean, they did have 3 million people watching the verdict. But when I went to, so they're not live with it now because it would be there. They do not have it listed in their main videos. And when you go to their live, these are now all pay to watch, which is interesting. I didn't know you could do that on YouTube. By pay to watch, do they mean be a member or pay per video? I don't know how they're doing that, which is interesting. So those are linked to pay to watch. These are recently uploaded videos, and all of these are different shorter things. So I don't know what they mean by pay to watch. So these are pay to watch the trials, which is really, really interesting. So yeah, I don't know what they mean by pay to watch. Watch the courtroom drama unfold live and get in-depth legal analysis of the day's biggest crime and law stories. $199 recurring billing plus applicable taxes. First 7 days free. Cancel anytime. Isn't that interesting that they have added? I didn't know you could add a pay to watch because it doesn't say members, which is interesting. I'm not surprised. I wonder if Law & Crime is doing that to try to I don't know if pay to watch is new. Are they allowed to commercialize public viewings? They're going to. But when it's live, it's not. The live trial is not pay to watch. So I don't know. I don't know if that's new. I've got questions. I will ask those questions. So it's interesting. I think they're trying to limit people rewatching their content. I think that's what they're trying to do. Because their content was used. They want the views and the money on their channel. That doesn't surprise me. Let's see. I think Waldman believed what he said. I don't think it was defamation. The jury disagrees. But I think Waldman believed what he said. It's interesting because the way that the jury instructions were, it's like, whose state of mind? Depp's state of mind or Waldman's state of mind? There's some questions there. Rottenborn is trying, but there's some questions of law there, and I'm interested. So maybe do a look-see into Law & Crime YouTube section. I will. I've got questions about it. It looks like it's like pay-per-view for court proceedings. Yep. Which would make it even easier. I wonder what their agreement is. I'll take a look at it. I'm actually really curious, but that's a whole like me asking questions in the background with the pay-per-view. Oh no, Elaine rubbed off on Rottenborn. Damn it, Elaine. Rottenborn needs to pick a lane and stay the F in it. Lawyering 101. You're doing it wrong. I think he's trying to argue arguendo, and it was like, if this and this and this and this, it was hard. Emily said he's trying to pull she was lying about this and he's knew, so he's lying, but she didn't lie, and he knew, so he's lying, but she didn't lie about anything else, we swear. Kind of. Josh Drew said he walked the officers through the damage. Rocky talked about the damage, so they are saying that they all lied, including Amber Heard, or that she cleaned it up. Or that it happened after Depp left, which the timing doesn't work because the officers were like, we didn't see any damage. But also what the officers consider damage and what they consider damage is interesting. Law and Crime has started a TV channel. I'm not surprised. I mean, Court TV has one, and they are a large media. I mean, they are a large media entity. And the news channels like that get whitelisted on YouTube. So they get shown to audiences more, like when it's on the watch page and stuff like that, which is something that independent creators have to fight. And I mean, unless you're Mr. Beast, who's basically a media network at this point. But there are definitely, YouTube has a kind of rating system. We're just hoping to fall into the rating system. The thing is, when I try to fall into the preferred channel rating system, I go and talk about something like Balenciaga, and then they get pissed at me all over again. It was months. It was months when I talked about the Ghislaine Maxwell and Prince Andrew stuff. Months for my channel to recover, because all of a sudden it just wasn't showing up for people. It wasn't getting populated in the Discover Now and the Up Next. It just was not getting shared by YouTube. It was like, oh no, what we're not doing is sharing those topics, which is part of why the members are so important. And the sponsors on the sponsors on the podcast are so important, because it allows me to be an independent creator and be like, it's fine. That isn't part of the whole YouTube streaming TV thing, is it? I get offered a subscription trial to get access to various things on YouTube streaming service all the time. YouTube TV is different than that, from my understanding. Weird. I don't have to pay to watch it. Maybe a US thing. I don't know. You have to pay for the right to watch the TV stream. That might be what it is. And I definitely don't have a TV stream and don't want to. It's a whole different thing. Starting a media network sounds awful. Kimberly said, I swear I could have won that case for her, and I'm not a lawyer. If she'd allowed her lawyers to work, it would be over for her, lies and all. I think Rottenborn had a strategy that he wanted to see through. I think that strategy was much more refrained than what we saw, and that's not the story she wanted to tell. And at some point, she's going to get on the stand and say what she wants to say. There were times where Elaine would ask a question, she would answer, and you could see Elaine being like, what? Like, that's not the answer Elaine was expecting. And with how long Elaine has been on this case, that was stunning to me. No damage by JD does not equal no damage by Amber Heard. I agree. Thank you, Emily and Mods, for a third stream this week, not counting the amazing stream of watching you record the podcast. Also, more food court, please. More food court for sure. What I learned from this case is if you're abused, call the cops and don't call a news agency. It's fair. What lawsuits have you been mentioned in? We were supposed to come back to this, Mackenzie. So, from memory, we have been mentioned a lot in the Toddy Westbrook litigations. A lot in numerous lawsuits. There was another one we came up in that I'm going to forget. Now I'm like, I put this off for later, and I'm like, I can answer. Well, I feel like we're now in the Amicus by the most tangential thing ever. But we were, the Tati lawsuits, we were in quite a lot. Oh, that's right, Lindsay, Nate's lawsuit. That's right, Nate, the lawyer's lawsuit. So those are the two, Nate and Boozy. I was not in the H3 lawsuits and hope to not be. I'm not relevant, but yeah, the Nate lawsuits, which was funny. Was I mentioned in the Ethan Klein suits? I don't remember if I was, but Nate's and the Toddy Westbrook ones are the ones I remember the most. I had forgotten. Sorry, Nate. I didn't mean to forget. And then this one, kind of, sort of tangentially, which I thought was funny. I had no idea that was there. I would think charging for streams of the court proceedings would violate the court order regarding videotaping of the proceedings. Charging for a TV stream on like a YouTube TV thing would not be weird. The court order of no recording would not apply, because if it's being streamed, they've gotten permission to stream it. So if it's being streamed, that permission's already been given. I don't think paying or not paying, you might not own copyright in it, but I don't think paying or not paying for it matters. Like, you have to, court TV, what they don't stream, what they show on TV, I think is cable. So you have to pay to have access to court TV, if that makes sense. So we covered the lawsuits I've been mentioned in, I think. Thank you. First, you have to circle back and catch us up on Britney versus Yeeted stuff, and then you can start a gaming channel. We have so much Britney stuff to cover. I think that's going to be next week's podcast. That I've started prepping it for the podcast. Emily, check your email for Murdaugh picks from today. I will after stream, and then we'll catch up on Murdaugh. I think on Tuesday will be a good plan. I emailed you the email that includes the letter from the Economics and Commerce Subcommittee. Thank you so much. I will, or my team will check for the emails. Jen said the ego on her is nuts. She's not Gloria Steinem. I mean, and maybe wants to be, but this isn't going to help. It's super fascinating that all of this is being said while Amber Heard outright taunted JD to see if anyone would believe that he was being abused. That audio is never addressed. Pixie Doll said, "Oh no, people actually watched the trial." Yep. That's a fake quote. LMFAO. I know, it's like Lamau. What? Fake quote? What? Raya said, "You rock, love the channel." Thank you for it. Got my merch. Yay. Awesome. Question. What was your first concert? Mine was Elvis. That's rad. Love and happy holidays to you and yours. I always love this conversation when it comes up. We talk about this a lot. Chat, feel free to drop your first in the chat as well as we talk about it and finish up answering questions. My very, very first concert was Paula Abdul. I think I was in 6th grade. It could have been 7th grade, but it was Paula Abdul. It was great. It was great. It was with a friend, like a friend's parents took a bunch of us for a birthday or something. So I loved it. What's the best place to get the backstory on Murdaugh before the trial starts? I have a few podcast episodes and episodes here covering kind of doing an overview. The Murdaugh Murders podcast with Mandy Matney is fantastic. It is a deep dive. So that is a deep dive backstory. They've been covering it for like 2 years. So that's there's other podcasts on it. I have not listened to them, so I don't know how they cover it. I find Mandy Batney to be very respectful of victims, and it's something that I appreciate about their podcast. So that is, if you want all, that is a good place. I have overviews on my podcast and the channel here. So if you just, there should be, do I have a Murdaugh playlist? There should be a Murdaugh playlist on the YouTube channel. Let me go look real quick. I believe if there's not, I will make one after stream so it's easy to find. I'm starting to try to break things up by case so that we have it. So let me just take a look. Playlists. No, I don't want to take a survey right now. Thanks. But no, where are my... They move things around a little bit and it always confuses me when things get moved around. There they are. I don't have a Murdaugh playlist yet. Oh, I need to get back to Rust too. There's other stuff going on. I don't have a Murdaugh playlist yet. I will add that after stream. And that will make it easy. So as long as we have a note. Yes. Thank you. Tech Family's like, you don't have a Murdaugh playlist, like, just stop looking for it. I love seeing all of your first concerts. It's fantastic. It's fantastic. Nicholas said I can lend you some Swedish cursey words for the Amicus briefs. I'm not going to pronounce this well. Helvetus Jalva Rovhal? Rovhal? I cannot. I need to hear things, but thank you. I love it. Tor said I work in domiciliary care and we have a client and a colleague called Elaine. I can now only read their names in the style of EDB. Elaine! Professor of Logic, with all of the LawTube drama that went on, I just wanted to thank you for being you, keeping it real and about the law. Great work. Thank you. I mean, if I was going to be a drama channel, I would be, but I probably wouldn't talk about LawTube drama. I find drama is thoroughly and well covered by commentary channels, and I appreciate that. But yeah, I like to talk about this. Occasionally we will be like, ooh, and did you see on Twitter it said this? But as it relates to the cases, I do a bit more reacts content over on our members only spaces, but still it's in line with what we do here. Mama C said, EDB, we are not law and crime law nerds. Nope. We're better because we have you. We had great coverage and supportive, not mean chats. We did. And that's the one thing that's really important to me that I can, because I'm not a media company, I can control that a bit better. I don't think they moderate their comment section at all. They should just truthfully turn it off. But that's their choice. But no, Law and Crime likes to claim videos, which is interesting. Matthew, hello. I think they've been saying that the jury could find that Waldman believed that there was no damage, and so he had mens rea for perjury when he blamed her. I think they were trying to say that Waldman believed there was no damage to say that he had malice because it was a knowing disregard for the truth. I think that's what they were trying to say. So, question, when you have cross appeals like this, could JD's team mention Amber Heard's argument in her response brief and their response to her, e.g. about no damage? I mean, they'll mention it in their brief, but it doesn't really, it comes up in their reply, but it doesn't really matter in the other brief. So, yes and no. We all know lawyers are, by their job, biased towards their clients' POV, and so will say anything to win their case. I mean, they within the bounds of ethics, they shouldn't say anything. There are ethical boundaries, but yes, zealous advocacy. Something can't be defamation if society knows not to trust it. That's a very, very, very good point. Like, hey, we know that lawyers are advocates, so obviously what they say is advocacy. So everything comes across as advocacy. So I appreciate that. Alora said, I think he is arguing that there was damage, but Waldman knew police said no damage, so he should have known. He should have come to the conclusion that there was no damage. The fact that there was damage was a coincidence. Watching I said roughing up doesn't necessarily mean damaged. He could have meant that they trashed or made a mess. And I think that's actually what he meant, is that they made a mess. After parties, there might be mess, but no damage. Any updates on the Andy Warhol case? I will be doing that when I sweep cases for the end of the year, but they are in the briefing stage at the Supreme Court. Ash said, YouTube TV is live TV like Sling Dark TV Stream or Hulu TV. Thank you. I have not tried YouTube TV. Have you seen the compilation vids of you and other lawyers by Joe Smithy and the one of just you with all your Elaine clips? I have not seen the one of just me with all the Elaine clips. I have seen some of the trial compilation videos. I thought they were hilarious and very clever, of all the lawyers reacting to different things. The thing about trial coverage is I didn't get to watch anybody else's coverage. And I enjoy other people's coverage. I didn't get to watch anybody else's coverage because I was so busy covering the case. So I loved seeing how everyone else was responding to the things I was responding to. I thought that was really fun. So I love, you guys, I love seeing all of your, oh my God, I can't believe how dark it is outside. Seeing all of your first trials. I'm using this stream right now to distract. My 11-year-old cat is very, very ill. I'm sorry. No treatments are helping to break her fever, so she will eat. It's been 2 days. Thank you for what you do. Having sick Pawnards, it like hurts your heart like nothing else. So we are sending you all of the Lawnard love. Tara said you were right, Emily. AH has exposed herself. Both sets of cops saw no damage. Her friend, Miss Mars, saw no damage, and Skip's beads and pics were in Penthouse 5. Isaac timeline for the puddle of wine is critical because he went in and out 2 times. AK said the fact that the amicus briefs were written by individuals who admitted to not watching the trial should immediately discredit them. Well, it shouldn't matter. Truly, the amicus briefs can be based on the law. Like, hey, the judge got this aspect of the law wrong. That's what it's supposed to be. It's supposed to be about the law, but it's not. So let's see. Emily, Tony Ortega spoke to the foreman of the Masterson trial, and they literally used the Rottenborn argument, not enough evidence, just their word. It will be, I need to go and look what they said, because I've heard conflicts about what the jury said about the Masterson trial. So I need to go look. But it is a problem with delayed reporting cases that the jury's like, look, this is very much, they said, really, because it's delayed reporting and it came so late after the fact. But one of the victims did report to police. They were discouraged to report. That's why Scientology came up into that case. So I will be very interested to see what the jury said. When I was asked in a couple different publications about what the attorneys should be looking for when they do these cases and ask the juries, I thought in voir dire, the lawyers should be very mindful of Depp v. Heard and ask the jurors about Depp v. Heard. We'll see if they did or not. I don't know who we're talking about with high school. Don't know if that. Are we talking about Amber Heard? I think she said by college age, to be fair to her. So I think she said college age. I don't think she said she was in college. But yes, I extrapolated that to abuse on college campuses. I imagine that's the implication that was desired. Let me actually pull that part up so I can be accurate with my language. But that's the implication, or that's the thought I was left with, but that might be, Yeah, it says, like many women, I had been harassed and sexually assaulted by the time I was of college age. So my mind went to the issue on college campuses. That might be why she said by the time I was college age instead of by the time I was a young adult, because it brings that to mind first. If JD's appeal doesn't happen, isn't it a slippery slope for clients because they can be held accountable for their lawyers' statements? Just want to know. This is a very specific circumstance, but I think there will be arguments in courts that lawyers can be held responsible. I think the distinguishing factor will be saying, no, this lawyer was just hired for this purpose and not a spokesperson. But when lawyers are acting as spokespeople, will that potentially change the way they act? Maybe. We'll just have to see. But also this applies to Virginia. While other courts might say, well, Virginia's doing this, Florida's going to be like, yeah, and we're Florida. We don't really care what Virginia's doing. So it just really depends. But it could be an argument for those that would seek to hold clients liable for what attorneys do. Jessica said, I forgot about the cursey word when my 7-year-old gets home, and now he just yells Emily every time he curse. Jessica's 7-year-old. I am sorry. My 10-year-old does the same thing, except he says, Mom. He's like, Mom, you said the bad poop word. That's what he says to me. Mom, you said the bad poop word. You said the bad poop word. The bad poop word. Amica brief creams for those chafing bindings. This brief was chafing to me. I'm chafed by the brief. The brief is chafing. I need the Amica because the brief has chafed me. We have 2 more super chats and then I'm going to have to yeet at 3 hours and 45 minutes. Nicholas, dear appellate court, I use roughing the place up and damage synonymously. What do you mean with that makes no sense? I use roughing the place up and damage synonymously. Leah B said, thank you, as always, Emily, for providing entertaining insight to these cases. I'm fighting all the cooties right now, and this is making it easier. I am glad. I love streaming with you guys. Oh, wait for Nick's comment on this law and crime. I mean, law and crime as a whole. Every so often, you got to drop the bad poop word. I agree. Susie Q said the Bay City Rollers. I love this. You look very pretty today. Thank you. This is my fax hat. If I get closer to the light, you can see the 3D fax. And you guys, we have the ones that say not fuckery on the back in the Law Nerd shop. It's so dark. It is going to be hard to see, but I need to put a picture of this up on social, but they say not fuckery in black and black on the back. I don't care if you don't like it, Fred. Fred's like, chat. It is so good to see you. So good to see. Fred is over me streaming. It's been a long day. It is so good to see you. I have some work to finish up. I've got some podcasts to record, not today. I will keep you members posted for behind the scenes podcast recordings if I record this weekend. And we will be pre-recording for the weeks that I am gone. Maybe we'll cover the Murdaugh hearing on Tuesday. Let me take a look at what happened and see if I can help break it down, even though it's not live. It's not like a day by day, it's a pretrial motion. So maybe that'll help. With that, I appreciate you. Thank you for being here. Thank you for being Law Nerds. Don't forget to do the YouTube-y things if you want to join us on the members, Law Nerds Unite, or here on the YouTube channel. And with that, it is time for me to go. It is time to go. Bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, LawNerdsUnite.com. Happy to have you. Support what we do here on the YouTube.